Hello, guests. Good morning. I'm just here to announce that we are waiting for the Honorable Chief Justice of India. He's expected to be here within next 5 minutes. So we are just waiting for him. Once he is here, we will commence our program. Thank you.
Good morning, ladies and gentlemen. We welcome our Honorable the Chief Justice of India, Honorable Justice Suryakant. May I request our learned Attorney General for India, Mr. R. Venkataramani, to please come on the dais. Professor S. Mahendra Dev, Chairman, Economic Advisory Council to the Prime Minister. Mr. Suman Berry, Vice Chairperson, Niti Aayog. And the delegates who have come from outside Delhi, more than 100 delegates from 22 states and various union territories. We welcome you all and all the delegates who have taken time out to come on a Saturday morning to attend this session on behalf of the Bar Association of India. Before we begin the formal proceedings, may I request presentation of bouquet to our distinguished guests as a mark of our respect and warm welcome. May I request my colleague Vikrant Yadav to present a bouquet to the Honorable the Chief Justice of India. May I request my colleague Mukesh Kumar Singh to present a bouquet to our Attorney General for India. May I request Mr. Roshan Lal Jain to present a bouquet to Professor S. Mahendra Dev. May I now request Ms. Bhavna Joshipura to present a bouquet to Mr. Suman Berry. We now begin the inaugural session of the BAI National Rule of Law Convention 2026. This convention is being held under the theme Legal Reform Roadmap to a $10 trillion Bharat. And what it means and how this topic has come up, I'll request our President, Mr. Prashant Kumar, to give his exposition on the theme.
Good morning and welcome everyone. As Amarjit has already said that there has been a lot of enthusiasm for the convention and we have attendance from 22 states. Let me first welcome our chief guest, Honorable Justice Suryakant ji. In fact, it is his most energetic and impassioned championing of two issues which is behind convening of this subject and this convention. That is, in Paris, the way he made a pitch for India and how Indian legal system is gearing up to ensure two things. One, how to support the Indo-French year of innovation, and how to support the EU-India free trade agreement. So after a long time, at least I could see a leader of Indian judiciary taking up this cause, and Chief Justice has been going everywhere as a champion of India and Indian economy. Then we thought that we must have a composite dialogue where the leaders of the policy sector are there. So the key institution for policy making and planning for India is Niti Aayog, And we are very honored to have the Vice Chairperson of Niti Aayog, Mr. Suman Berry. Then we have the Chairperson of Economic Advisory Council to the Prime Minister, Professor Mahendra Dev, not just an advisor, but a scholar, and a scholar who covers a very important strand. That strand is agriculture as part of the economy and agriculture as the part of the modern economy. So, then we have the highest law officer and the constitutional functionary, and our honorary chairman, Attorney General, Mr. R. Venkatramani. Again, you know, in my background paper, I have made reference to a verse from Meghaduta, but I think in the convention report, we'll look forward to 2 lines of poetry from Venkatramani ji. And of course, our President-elect, Mr. Amarjit Singh Chandiok, who is Doyen of the Delhi Bar, and my all fellow office bearers of the Bar Association of India, Mr. Jaideep Gupta, Mr. Shyam Diwan, and Mr. Vaidyanathan, and I won't take this time to acknowledge everyone, we'll do it in there later on. So, but we have the full BAI team present here, and we have the President of Bombay Bar, Mr. Nitin Thakkar as well. So, generally we are talking about India becoming a 5 trillion economy. Why we are talking about 10 trillion economy here? So that is the question which comes first. And that is where we thought that this convention should justify it. Justify in the economic sense, justify it in the national aspiration sense. Because 10 trillion is not just a figure, 10 trillion is a baseline by which India will become a middle higher income group economy, which will support acceleration in per capita income, expand market, though we are 1.5 billion in population almost, but the purchasing power which drives the manufacturing and internal consumption is still restricted. And it will expand and become an engine of further accelerated growth once we reach the stage of 10 trillion. Now the question is, India has a trajectory to reach 10 trillion. Whether we do it by 2032, 2035, or 2040 or beyond is what we are discussing today, and how accelerated legal reforms are going to support it. So I will not run through the slides, but what I have done is made a presentation to just give some thoughts, some ideas that how we have to go about. Now, we require for a 10 trillion economy capital infusion at a scale and policy reform which has not taken place till date. I think we have. This monitor is not working. Sorry. So, what we are trying to argue is that the economy we had pre-liberalization and the economy we have today requires a very different legal architecture. We have a Contract Act which was conceived by the British during Victorian era, 1872. Every other law has seen change, amendment, new laws have been brought in, but contract law has remained frozen, and it has remained frozen also after economic liberalization in 1990s. So when India was under colonial regime, the contract law was brought in. And please remember in the history that the Britishers came to India not only with battleships, with cannons and firepower. They came armed by a charter of East India Company. That was a legal instrument. And a part of instrument of colonization was the Contract Act. The Contract Act, which suited the commerce of England at that time, and a Contract Act which also suited the colonial ambitions of the British in colonies like India. Why? Because for trades, sending ships full of goods, receiving goods, you needed a contract which gives highest value to certainty. So the Contract Act which we have has the highest value to certainty, legal certainty. And once you have signed the contract, the basic assumption was that the both parties, at least the commercial parties signing the contract, have intelligence enough to understand their own risks, understand their own rights. It is not a social contract, it is a commercial contract. So that assumption. But how did that assumption operate when you had a colonial power and you had other smaller states, entities with whom you are signing the contract? So the certainty of contract law consolidated the colonial ambitions of the British. It served them directly. India gained independence. But we chose an economic model which was centered around state capital, which means that the contract law, which was made by the colonial power, did not appear to be so jarring and out of sync, because the state power also wanted to have an upper hand in terms of application and enforcement of contracts. Because the decision making was to be sanctified at the public sector level and enforced. So the whole contract law developed in terms of breach and enforcement. So that's how till 1990 we did not have much space for private investment. 1990s we started private investment, we started public-private partnership, we invited foreign investment, but without this basic change in the understanding of contract law, after 1990s, the private disputes no longer remained bilateral private disputes. At least the bigger disputes logged a lot of economic value, which did not exclusively belong to the private parties who were litigating before the court. That value belonged to the banks, public finance. That value belonged to the retail shareholders. That value belonged to the foreign investment. What we crave, which is a stable, deep investment, long stay investment. So this did not serve that purpose. Then again, we look at legal reform. We have done, it is not that we have not done, we don't have jurisprudential this thing. Supreme Court and High Courts have been very progressive in developing jurisprudence in sync with the time. But that development happened in a way which did not permeate to the private sphere. So after 1990s, when PPA contracts came, other came, Supreme Court has developed administrative law in the most marvelous manner, looking at arbitrariness, looking at malafidis of state conduct, looking at bona fides of decision making. But that was always at the intersection of the state and the private party. It was never at the intersection of a private and a private party. So we tried to, create solutions. Those solutions got directed towards how to expedite, how to deal with the backlog, how to deal with more efficient judicial system, more number of judges, better infrastructure for the court. But what was lacked was the legal infrastructure. Legal infrastructure of the kind which recognized locking of economic value in a private dispute, wastage of that private value in that private dispute. As the time went by, the disputes go from one level to another level, from arbitration to challenge to enforcement. So, value frozen. And we continue to apply the principles of interim relief, which are structured around balance of convenience, and that balance of convenience somehow, because courts decide what comes to them, they can't decide what is not before them. So what was not before the courts in resolution of all these disputes was what is the economic impact or footprint of these disputes beyond the competing claims of private litigating parties before it. That never became a criteria, except, and here we also see that what is the remarkable capacity of doing innovation of our judicial system. The courts recognized, even in IBC proceedings, how to protect the interests of the home buyers. So that was an implicit recognition of preservation of economic value, which was not, in the frame of IBC. But the larger interest of the home buyers, Supreme Court deviated and expanded the scope of inquiry to protect that. So our jurisprudential foundations all exist, but they have not been concentrated. So that's why when we look at it, we remain 163rd out of 190 economies on enforcing contracts. We have average 1,445 days to enforce a commercial contract. We have improved in ease of doing business by 23 points, and we are 63. Now Singapore resolves a commercial dispute in 164 days. OECD in 590 days. What is the other aspect? The other aspect is that because of the guardrails of good faith and check on opportunistic conduct of parties in a private litigation under a contract, opportunism has become a device in litigation to cause delay. There are so many instances where one party loses because of delay and other party gains due to delay. The delay serves the purpose of one party. And somehow, in law, we don't have a guardrail against that. So opportunism becomes the foundation of many parties' litigation approach. And what is the snowball effect? Snowball effect is delay. The docket gets clogged. Somehow reasons are found to seek adjournments. Somehow much more applications are filed. Many more contours of disputes are created. Why? Because of the opportunism which the current system is not geared up to contain. So it holds back the entire judicial system where judges work overtime. They sit from morning to evening, then after that write orders and judgments, correct them. People only look at the court sitting hours, don't look at the other work of the judiciary. which is much more than what happens in the court. So this becomes almost a thing which we are trying to grapple with for last 3 decades, but not have been able to find solutions. So that is why, if we look at the economic sense, the contracting parties, private investors, foreign investors, looking at this scenario that our value may be locked in a litigation or in a dispute, they overcompensate. They make contracts very, very complex. They purchase insurance in the security of the terms of the contract because they are entering an environment where the solution is not how to find a legal remedy which sustains the contractual relationship, but a remedy against the breach. So our today's framework is a term of the contract, an overcompensated contract, and its breach. So which means the courts intervene when the value destruction is taking place. So that is what holds back the entire system. And in terms of calculating internal rate of return, it gets eroded. These factors are not mapped. Then risk premium is built into the cost. Manufacturing becomes uncompetitive. Equity gets destroyed. And the long-term stable capital which we are looking at, it faces a huge deterrence of what is called a legal tax or a legal risk of a prospect to get frozen in a dispute. So, in my estimation, we have, Niti Aayog and the advisory members. We require 12.5% growth if we want the economic trajectory of 10 trillion till 2032. We can hit double digit with the efforts what we have been doing. But this extra 2.5% or 2.6% has to come from somewhere. And that is where we look at the legal reform. Whether legal reform, by merely unlocking the value, economic value frozen in disputes, destroyed in disputes, can add to that. That is what this convention is about. Can we find pathways to that? And we need 12% manufacturing growth to achieve this. Manufacturing essentially means that there are web of relationships. One default, one dispute impacts 100 downstream, upstream legal relationships. Supply chains. So it destroys the entire economic template itself. It has many effects. So how to create a legal system and an environment where opportunism is disincentivized, good faith is brought into the contract dispute resolution framework, where the parties don't have to only insist on enforcement of their legal right, but also their implicit, obligation under the contract, because when two parties come, that is to share the fruit of the enterprise. If one party gains by destroying that fruit and still gets away, that is where the whole problem comes in. Sorry, I'm taking a little longer. The last trend which I wanted to put across is India, before the Contract Act came, a formal legal system came. I'm not faulting formal legal system. It has served India a lot. But before it came, our economy has always been an economy driven by uncertainties of a monsoon. We were agrarian economy, which means anything you contract even informally, there is a good chance of getting it breached because you can't control the monsoon. India has been a monsoon nation, so harvest, the supply chain emerging from it. And it is true even in today's economy. Our manufacturing inputs come from agriculture sector. So uncertainty is built in, and it's a dichotomy that we are giving certainty the highest premium in our legal system when it comes to enforcement of contracts. So good faith in unit right, in civil law, in United States, in Canada, and even even in England itself is now a major factor. France had always, but it amended its law in 2016 for a direct clarification of good faith being a factor of it. And that is also the thing which, if we are looking at India-EU FTA and other FTAs, the investors will be looking at. Whether India has trust-based system where their value doesn't get locked in disputes, or whether they have a system where a party can go and destroy the economic value. So I think these 2 days, with the guidance of the Chief Justice, with the Niti Aayog, with PM's Economic Advisory Council, we'll try to find these answers. Thank you very much.
Thank you, President. When we were preparing this topic, a lot of our speakers whom we had proposed to speak on the upcoming 2 days, we had this query as to what is this complex topic that you have selected, and if you have seen the list, we have some very interesting topics which are not regular in our routine thing. So our exposition by our President is a brief background on what was the idea behind it. Now may I request our Attorney General to please give his presentation.
Honorable the Chief Justice of India, the jet speed pace with which he moves from event to event and place to place, if only all of us could capture that speed and our institutions could emulate that speed, probably this conference, deliberations would have realized it very fully. So thank to the Chief Justice presence here today, and Mr. Narendra Dev, Chairman Economic Advisory Council, and Professor Mr. Berry, who I often encounter, and he allows me to have a peep into his intellect. Thank you for being here today with us. Now, why are we assembled to talk about economy and law? If long ago Adam Smith was talking about the invisible hand, the butcher, the candle maker, and then he said it is not that they're benevolent, but something invisible. I don't think we need to talk about that invisible hand any longer. And if law has to be meaningful, relevant, purposeful, and be also what one may call an economic efficient quotient of our national development, we need to constantly and continuously engage in deliberations like this. And Bar Association of India is always forward-looking. It strives to kindle big thoughts for a brave new world. Its engagement and exploring emerging and nascent dimensions of rule of law are invigorating. Having said this, I look at how the history of economic thoughts are so intertwined with ideas in law and legal principles integral to and accompanying economic growth and development. Capital needed a few legal ideas for its emergence and sustenance. The idea of contract in its most developed form, with all its attendant principles, was one of them. So also the idea of property, with its rules of claims and succession. Besides the thought that the movement from an agrarian society to a capitalist society was triggered by commodity production, exploitation, and surplus value, etc., and the accumulation of capital was a pure economic phenomena, there is room for thought that the legal system is not merely a superstructure. Today, a legal system is not merely a set of rules, primary or secondary, as H.L.A. Hart was talking about. The legal universe is composed of the idea of constitution as the all-encompassing rule of social order and all other subordinate principles in aid of that basic document. In Germany, therefore, it's rightly called the basic law. This legal universe will be incomplete without institutions for effective accomplishment of the rules, norms, goals, targets, namely a policy-making executive and an independent enforcing judiciary. Both these institutions deserve their special set of rules and norms. But beyond these indispensable institutions and their functioning lie many facilitating aspects. These are in the domains of what is often described as good governance. We have a good deal of debates on good governance. Institutional accountability is integral to it. In asking the question as to what would constitute accountability, we get into rules and regulations, transparency, but we fall back on correctional mechanisms. The reason for dwelling into these subjects, when you want to talk about India becoming a global giant, is that economic development or community wealth development cannot be conceived, designed, or executed without several associated factors. Constitutional democracy is one factor, and we are in no uncertain terms committed to it. Though China is an example of a controlled but free economy, and not driven by democratic regulation. Fundamental to all growth in terms of generation of resources which are essential to fulfillment of life is equity and fairness. How do we go about distributing equal fulfillment for all? Constitutional guidelines and directives are like signposts. We need constant road laying and mapping of abiding by equity and fairness. But what legal reforms can be conceived to be in aid of all of them? What aspects of the legal system are seemingly obstacles or bottlenecks or retardants? It may be too presumptuous on my part to talk about them in the presence of accomplished economic thinkers present here. But then we know certain familiar terrains in the context of an interconnected world with tenuous rules, but working on apparent norms and give and take. These are investment of financial and other resources and their attendant demands for a variety of benefits. Perhaps without the global flights of financial and other resources, all our endeavors to execute domestic GDPs is unthinkable. So we are called upon to devise exchange rules relating to virtually every flight of global or even domestic resources, or change them where necessary in order that no wastage occurs. Expedition, quick and fair returns and certainties are to accompany such rules. To reiterate, fairness and equity will always be the all-round denominations in all this. The existing legal framework and institutions of delivery, namely judicial institutions, figure here. It is in this context that we may deliberate on legal reforms. Is the Indian legal system, namely its law of contract, economic and financial regulations, its tax regimes, and other laws relating to access and use of land and other resources, are under stress, somewhat dated? Equally so is our adversarial system, delivery system, because of huge burdens, is gasping for breath. When we talk of reforms, we tend to equate refinements to the system as reforms, though they can be, but the question would be what refinements to all of the above would be good and sufficient. We need to insist, therefore, both economic efficiency quotient as an index of our major laws and the justice delivery system. This means that every citizen of India should be incentivized to be engines of growth. Let me gather a few thoughts on in respect of what aspects we are to urgently reflect as to radical changes or system improvements as to provide answers to expedition, quick and fair returns, and certainties in all our dealings and transactions. Firstly, as in all change talks, process reforms will be important. Much of our institutional functioning have process bottlenecks. Despite talks on one-window clearances, we have some lingering matters. One such issue is our environmental clearance and approvals. Besides the National Green Tribunal, Supreme Court is the guardian of sustainable development oversight. But it had to grapple recently with prior or ex post facto clearances. The laws in this regard are either unconnected or uncoordinated. We need to have a consolidated environmental code. The Environment Act deserves a close look and reorganization. The second is our investment regime. While ease of doing business is being addressed, maybe we need to talk about a comprehensive investment code. Third, our land-related laws and real estate and infrastructure issues, which are closely linked to fairness and equity. Fourthly, enhancement of our export potential and the relevant incentives to flow from legal regimes, most importantly, and finally, revamping our adversarial system. Maybe we can think of about a dedicated investment court with components of a settlement and mediation. Experiments elsewhere in China, UAE and Singapore are to be studied. Let's also keep in mind that the Chinese BRI area will account for a significant portion of the world economy, such as 40% of global exports, and the Chinese investment in Golden Initiative has reached more than US 90 billion. The BRI studies thus link the nexus with the demands for dispute resolution concerning a whole range of commercial transactions, investments, energy use and development, environmental protection, construction projects, taxation, etc. Thus, we can see as elsewhere so in India, from contract law to corporate law, from debt law to insolvency law, from financial regulators to energy regulators, the demand is less law and more results. Political obligations follow economic activities, and democracy is all about the discharge of political obligation through law. So where do we stand? Should we follow the rhetoric of criticisms about the persistent effects of arbitration and our adversarial system, as they are called, and trace the footsteps of those who have gone ahead of us in building institutions in the expanding field of alternate dispute resolutions or approaches? I briefly mentioned about the Chinese Belt and Road Initiative. In 2018, the Supreme People's Court of China has established what is conceived as a one-stop commercial dispute mechanism vis-à-vis international trade and commerce in and with China. The China International Commercial Court is thought of as a multi-dollar courthouse offering an array of services where commercial disputes of parties can be addressed. By a notification issued in July 2022, the scope of the mechanism has been expanded to include additional group of arbitral institutions in mainland China, as well as the Hong Kong International Arbitration Center. We see many things happening in other parts of the world. It seems the CIC has therefore initiated collaboration with several institutions in the field of arbitration and mediation. It is said that law must follow the demands and footprints of our social changes. How do we blend non-negotiable norms of adversarial system with the flexibilities of mediation and conciliation? How do we script self-working accountability in contracts with voluntary sanctions for unethical breaches? How do we provide for self-correcting or periodic remedying in our contracts to avoid dispute generation and not be looking at dispute resolutions? These questions, I think, have some answers in themselves. I congratulate Bharat State of India for conceiving this conference and to engage all of us in nation building beyond 2040. I thank particularly Chief Justice for being with us again today. Thank you for your attention.
Thank you, sir, for giving your insightful remarks. Now, may I request Professor S. Mahendra Dev to speak and give his valuable perspective.
Honorable Chief Justice of India, Justice Surya Kanji, Dr. Suman Berry, Shri R. Venkatramani, Attorney General of India, other dignitaries on the dais, and esteemed office bearers of the Bar Association of India, and esteemed members of the legal fraternity, and respected colleagues. Good afternoon to all of you. Thank you for inviting me to this convention. At the outset, of course, I compliment the judiciary for the very good work in spite of some of the constraints. As mentioned earlier, the Honorable Chief Justice of India is champion of the Indian economy, and he wants to have higher growth for the Indian economy. And also thank you for inviting economists to this convention, because interaction of economists and judiciary is important for better outcomes in economic development of India.
In fact, in recent times, law and economics is one of the courses taught in Indian universities. So economists should learn legal aspects, and similarly, judiciary also should know about issues and policies on Indian economy. As mentioned earlier, if you go to the past, India's growth, at the time of independence, of course, everybody was socialist. So we had policies of, first 3 decades or 4 decades, we had a growth of only 3.5% per annum. And also many other countries, Southeast Asia, China, and others, went for liberalization in the 70s, late 70s and all. So we missed 2 chances. One at the time of independence, only state-led economy and all. And second, we are late by 15 years on liberalization. So because why I'm telling this, because some people ask me, sir, you are saying 4th largest economy and all, but our per capita income is still low. So my answer is, of course, the first 4 decades we lost, and that time per capita income was 1% per annum. So we have to run faster now. We are doing, which after the liberalization, growth rates were higher, and now it's much more higher. So India today stands at a defining moment in its economic journey. We are aspiring to move from a 4 trillion economy towards 10 trillion, and eventually 35 trillion economy by 2047. There are 3 goals of Viksit Bharat. One is to become developed country in per capita terms. The second one is the inclusive growth, in sharing of growth to everyone in the society. Third goal is achieving sustainability and climate resilience, because that's also an important one. Because recent geopolitical development underscores that India should move faster to renewable energy and secure energy security. On the growth, there were some estimates. I think, if we have 11 to 12% of nominal growth and 7.5 to 8% of real growth, we can achieve this 10 trillion and also the Viksit Bharat goal of developed economy. So our legal and regulatory architecture, which was, the earlier state-led growth kind of thing managed. But now we must evolve, in keeping these goals of 10 trillion economy and also the Viksit Bharat goals. So the law is not merely a support system for economic growth. It's foundation, very foundation. So predictable institutions, enforceable contracts, and efficient dispute resolution systems are essential for sustaining high growth and attracting domestic and global capital. As mentioned earlier, we are having lots of FTAs and all, which can, to attract global capital and also our exports also. So in public discourse, economic reform debates often gravitate towards what may be termed big reforms, tax overhauls, free trade agreements, and privatization. These are important, but as mentioned by the Attorney General, that the process reforms are also very important. It's not big kind of reforms, but process reforms are the nuts and bolts changes in governance. Individually, these reforms may appear incremental or technical, but collectively, these process reforms have potentially improves the efficiency, reduce transaction costs, and enhance both ease of doing business and ease of living. So encouragingly, India has already embarked on a significant reform journey anchored in deregulation and trust-based governance. So this shift recognizes that excessive regulation imposes what has been described as regulatory cholesterol, clogging the arteries of economic activity and constraining innovation. So the government's efforts in this direction are noteworthy. Several obsolete laws, many dating back to the colonial era, have been repealed in recent years. And further, the amendment of more than 700 provisions of 79 central acts, particularly through the Jan Vishwas Act, has replaced criminal penalties for minor procedures, lapses with monetary or administrative sanctions. So this has reduced the fear of prosecution and fostered a more business-friendly environment. So the Economic Advisory Council to the Prime Minister has been doing a lot of work on process reforms. For example, their work on voluntary liquidation of companies, shutting down a company voluntarily in India is noteworthy. Because the major delay in the voluntary liquidation of companies was due to notices not being published on time. So reforms in Companies Act led to more transparency in the system. So there is a change of notice period now that's published weekly and reduced average time from 499 days to 60 days because of this process reform. In addition, 94% of applications were being disposed of less than year now. So justice delivery is foundational aspect of for a growth-oriented ecosystem. Historically, enforcing contract in India has taken significantly longer than in global best-performing jurisdictions, like I mentioned 163 rank in the enforcement of contracts. So such inefficiencies not only deter investment, but also undermine confidence in the rule of law. So the scale of challenge is evident. There cannot be Viksit Bharat without ease of enforcement, contract enforcement. So as economic activity expands, the demand for dispute resolution will only increase, be it in commercial contracts, property disputes, or regulatory matters. So of course, technology the judiciary is using through digital courts, it has to be increased further. E-filing systems and AI-assisted scheduling, they're important. Specialized institutions can offer technocratic solutions, some of the problems. For example, the IBC, the Insolvency and Bankruptcy Code, had a significant impact on the health of the country's banking sector and redefined the debtor-credit relationship. So according to one study, IBC emerged as the dominant recovery route, accounting for 48% of all recoveries made by banks. Another important dimension of legal reform relates to the role of judiciary in economic policy making. While judicial review is a cornerstone of constitutional governance, more intervention in policy matters can create uncertainty. Sometimes more intervention can, This underscores the need for a balanced approach of the judiciary also, one that preserves judicial independence while ensuring that economic decision-making remains predictable and coherent. So in this context, it is essential that courts increasingly engage with the economic implications of their decisions. There are several reforms needed related to judiciary. I mean, I'll just list them, keeping in mind the time constraints. The first, judicial and dispute resolution reform. Second, decriminalization compliance signification. Third, as mentioned earlier, land and property rights reform. Fourth, tax and regulatory certainty. Fifth, financial and insolvency framework. Sixth, business law modernization. Seventh, labor law rationalization. Eighth, governance and administrative law reform. Ninth, criminal justice reform. Lastly, federal legal harmonization. So some of the things one can expand, but we can keep in mind. So what is the expected economic impact due to judicial reforms? For example, faster dispute resolution leads to increase in FDI inflows. Land reform leads to infrastructure acceleration. Compliance simplification can enhance startup growth. Tax certainty can lead to capital inflow stability, etc. So as recognized in progressive jurisprudence, the economic impact of legal outcomes on employment, investment, and growth must form an integral part of judicial reasoning. So this calls for greater use of interdisciplinary expertise, including economic and social sectoral inputs in complex cases. Ultimately, the vision of $10 trillion, and Viksit Bharat cannot be realized through isolated reforms. It requires a comprehensive transformation of our legal ecosystem, combining structural reforms with sustained process improvements, efficient courts, simplified regulations, and predictable legal outcomes will directly translate into higher investor confidence, faster dispute resolution, and enhanced global competitiveness. So as we strive towards Viksit Bharat, the law must lead the way, not follow economic growth. The future of India's economy will be determined not only by what reforms we undertake, but by how effectively we implement them, down to the smallest process, the simplest procedure, and help all sections of the society. So I think there is a need to have a group of judiciary and economists on legal reforms for this achieving $10 trillion economy or Viksit Bharat. So ESEP members will be happy to be part of this group. So to conclude, India's path to a 10 trillion economy requires a paradigm shift from rule-heavy based governance to rule-efficient governance. So legal reform must aim to first replace uncertainty and with predictability. Second, replace delay with speed. Third, replace discretion with transparency. So a high growth, inclusive and sustainable economy is ultimately built on trust in institutions and also private sector, and help all sections of the society, including common man and common Indian, and law is the foundation of that trust. Thank you very much.
Thank you, Professor Dev. Before I call our next guest, I welcome Justice Arvind Kumar, Judge, Supreme Court of India, Mr. May I now request Mr. Suman Berry to please come and give his address.
Honorable Chief Justice of India, learned Attorney General, and my good friend, Sri Venkat Ramani, who has been a frequent visitor to my chamber at NITI and has also delivered a lecture, a NITI lecture in front of NITI staff. My colleague and successor at the Economic Advisory Council to the Prime Minister, Dr. Mahendra Dev, the President of the BAI, the President Shri Prashant Kumar, the President-elect. Let me start by observing that I don't think there are many countries where the Chief Justice would deign to spend time to listen to such a wide range of speakers, and particularly to economists. So thank you, sir, for that, and also for the warmth, when we shook hands at Rashtrapati Bhavan, and your indication that you were interested in the work of Niti Aayog. And let me also say that many of the important points have been covered by Dr. Mahendra Dev. And what I will do is to some extent depart from my, as it were, prepared talking points to react to what was said by the President of the BAI and indeed to Dr. Mahendra Dev. So, as you know, the Niti Aayog is the successor institution to the Planning Commission. We occupy the same building, but it is a fundamentally different institution. And Niti is, of course, policy in Hindi and Sanskrit. So we are a policy commission, but it is also the national institution for transforming India. That's why it's capitalized in English. It was my privilege to be appointed to this post almost exactly 4 years ago in May of 2022, and it was, you would recall, from the Red Fort in August of 2022 that Honorable Prime Minister articulated the vision of a Viksit Bharat by 2047, and he chose that time for a number of reasons, but because it was clear that India had successfully emerged from the COVID shock, and I don't think we quite anticipated that we would emerge and have sustained our position as the fastest growing large economy. We can't take that for granted, but just to say that I think that is a tribute to, as it were, economic management in India. But as both Mahinder Dev and the President have indicated, we can't rest on our laurels. If we wish to become a Viksit Bharat, we have to accelerate growth. The point I want to make at this is that Prime Minister, both then and in multiple, as it were, other interactions, have indicated that the goal of Viksit Bharat is a modern society. A modern economy, I mean, an affluent economy is a prerequisite for a modern economy. And why do we want to be a modern economy? Because that is what allows for the dignity of all Indian citizens. So the economic growth is a means to an end. It's not an end in itself. Now, because many of the reforms have been discussed, let me just address 2 or 3 points which I think may be somewhat of a departure from the kind of thinking that we've already heard from both the President and the Attorney General, which is to say that there has to be a separation of powers between the judiciary, the executive, the legislature, going back to the traditional division that dates back to the Enlightenment and to John Locke. My point is that actually the difficult issues arise in the intersection between, as it were, these 3 entities. And the question that arises is, what is the mechanism for bridging these intersections? Let me give you a few examples. So, no parliament can commit the sovereignty of its successor parliament. Yet, the time horizon that investors need is 20 or 30 years. And jurisprudence in the United States on regulatory institutions indicates that regulatory institutions were erected as a mechanism for bridging between the judiciary, between the legislative horizon and the assurance of longer-term consistency. I would also talk about, as it were, the interpretation by the bureaucracy of decisions that come from the Honorable Supreme Court. So I'm advised that in the decision in I think 2012, and this was in the telecom issue, it was proposed that one way of allocating the scarce resources, the natural resources of the society, spectrum in this case, could be auctioned. But when we go ahead and we see the interpretation of that in the formulation of the 2015 Mines and Minerals Development Rules, auction has been indicated as being the sole route. Now, there's a lot of economic research that indicates that there are some cases where first come, first served makes sense, and it's unfair to spin all of this on the Supreme Court. What I'm saying is that we need fora and mechanisms whereby the application of, if you like, thought and research in going from the pronouncements of the Honorable Supreme Court to, as it were, rules, does not end up, as it were, impeding the economic progress of the country. I will just make 2 points because I'm as keen as the rest of you to hear from the Honorable Chief Justice. So, I think the question of what accounts for the risk aversion of our bureaucratic officials, I think, is a deep issue, and I'm not sure that we have a very good understanding of it. But the question whether it is indeed all the, as it were, entities that exist, the CAG and the EDs, but I would say that it is this shift of culture which is as important as some of the proposals that have been made by the president of the BAI. I would like to end with the point that the president made about India as a monsoon culture. So I had the privilege of spending 4 years at in the Netherlands as the chief economist of Royal Dutch Shell, and it's very interesting to note that because the Netherlands is basically no different from Bangladesh, it's a delta. And because there was so much uncertainty connected with flooding, essentially the point about monsoon, what did the Dutch invent? They invented financial markets, okay, as ways of offsetting the unavoidable risk in life. Let me just summarize the point I'm making, that there has to be separation of powers, but what we've seen in the war in the Gulf, there is inevitable uncertainty. So the question of, as it were, a range of fora, mechanisms for dealing with uncertainty in the modern world, of which legal reform is very important, I think is the larger context within which this discussion needs to be placed. And again, thank you, Chief Justice, for giving your time and also for your proactivity in these matters. And my thanks to the Bar Association for this invitation. Thank you.
Thank you, Mr. Berry. Now it's my singular privilege and honor to invite the Honorable the Chief Justice of India to deliver his inaugural address.
My esteemed colleague, Justice Arvind Kumar, Judge Supreme Court of India, Shri Suman Berry, Vice Chairman Niti Aayog, Shri R. Venkatamani, Learned Attorney General for India, Professor S. Mahendra Dev, Chairman Economic Advisory Council to the Prime Minister of India, Shri Prashant Kumar, President, Bar Association of India, Shri Amarjit Singh Chandiok, Senior Advocate and President-elect, Bar Association of India, Shri Amarjit Singh Bedi, Honorary General Secretary, Bar Association of India, Shri J.S. Maratha, Treasurer of the Bar Association of India, a galaxy of eminent senior advocates, not only from Supreme Court but different parts of the country, who are here to participate in this program, office bearers of the Supreme Court Bar Association, SCORA, Bombay Bar Association, members of the legal fraternity, friends from media, ladies and gentlemen. the theme for this 2 days convention, that legal reform roadmap to a 10 trillion Bharat, warrants serious consideration, not as an aspiration, but as a diagnosis. The Bar Association of India is the country's leading voluntary organization for the legal profession. And when it asks whether the existing framework can guide India to a $10 trillion economy, it is not posing a marginal query. It is, in fact, asking one of the most important questions the profession can put it to itself today. It matters because the legal foundations supporting India's growth over the last 3 decades were shaped for a relatively simpler economic moment. My previous speakers have very elaborately and very eloquently explained, but if briefly I refer to the liberalization of the 1990s triggered growth, expanded the middle class, and created a sense of economic confidence that the country had not experienced since independence. We must, however, be mindful that the legal functions that sustained that phase, such as enforcing contracts, registering property, and resolving disputes, were sufficient for a different era of commerce. Reaching a $10 trillion economy requires attracting capital of a very different kind. This is capital that is patient, long-term, and dependent on institutional reliability, whether it is a pension fund investment in infrastructure, a technology company transferring proprietary know-how, or a global manufacturer establishing an integrated supply chain. These are not short-term bets. They are commitments that unfold over time. What such investors seek before they commit is, in a sense, pretty simple, though demanding in practice. They need to know whether the legal system governing that investment will remain honest, consistent, and predictable over the years of their commitment. At its core, the question is one of trust. And I acknowledge and express my thanks to Mr. Prashant Kumar, Professor Dev, Learned Attorney General, and Mr. Berry, that they also centered around their ideas and thoughts around the reforms and development in the judicial and justice delivery system in India. It is not because merely about enforcement at the stage of breach of a contract, but about the continued integrity of obligations throughout performance. Such confidence among the investors enables commercial relationships to create the value they are intended to generate, and its absence builds the cost silently into every transaction and investment which are quietly diverted elsewhere. What brings us all here today, therefore, is to find ways and means to close this gap. I often reflect on the nature of disputes, and the difference from some 20 years ago to this day is quite remarkable. Commercial disputes were once relatively straightforward, centered on non-payment, breach of supply agreements, or clear questions of liability. Today, they increasingly arise from relationships of far greater complexity and duration. And the reason for this shift is not merely procedural. It is fundamentally economic in origin. As commerce grows in scale and ambition, it moves away from isolated transactions toward continuing relationships. A global manufacturer, for instance, does not simply contract with a supplier. It trains that supplier, certifies it, integrates it into a global quality system, and grows dependent on it over the years in ways no single contract can fully capture. at a $10 trillion scale, this is no longer the exception, it is the norm. Our commercial laws have served us reasonably well, and the foundations they provide remain sound. But the legitimacy of law lies in its ability to remain responsive to the society it governs. There is no need to discard the existing one. It is to enable the existing framework to grow so that it protects not just the moment of agreement, but the full life of the relationship. Our courts have already paved the way. In their approach to public contracts and legitimate expectations, they have demonstrated that the law can look beyond breach and remedy and ask what fairness demands across the life of a relationship. That instinct is already present in our public law. It is now time to carry it into the commercial spheres as well. The question then is how a legal ecosystem builds the kind of confidence that long horizon commerce requires. The answer, in my view, begins with predictability. This does not mean uniformity, which is neither possible nor desirable, but it does require that similar situations be governed by similar principles and that those principles will not change with the changes either in government or a bench. The second imperative is the development of a culture of dispute prevention. Courts and alternative or preferred dispute resolution mechanisms, such as mediation, undoubtedly play an important role, but they can address a dispute after it has already arisen. Therefore, what is equally important here is the development of a broader legal culture of good faith, a culture that encourages early engagement with emerging difficulties and treats the preservation of relationship as a legitimate objective, thereby ensuring that disputes are less likely to occur in the first place. When such a culture of good faith in contract performance is in place, mechanisms like mediation can deliver on their full promise. If we foster this culture and guard it jealously, litigation becomes the last resort rather than the first response. That shift alone would do more for India's economic competitiveness than many reforms that attract for greater attention. The third imperative, in my opinion, is specialization. The nature of commercial disputes today has outgrown the scope of the generalist framework within which much of our legal training has traditionally oriented. Disputes involving infrastructure, finance, or digital systems increasingly demand sector-specific expertise. The profession must invest in that depth, and legal education must respond accordingly and produce graduates suited to the economy they are going to serve. In fact, there is a lot of requirement of our judges also to require a periodical orientation, and for that I will sincerely make some efforts where some domain experts can have an informal interaction with the judges to understand the different nuances of the economic system so that they have a fair idea beyond the law books also. Similarly, I believe technology must be treated as part of the legal system's core infrastructure, not as an optional upgrade. Digital case management, AI-assisted research tools, and electronic proceedings directly affect the speed, accessibility, and cost of justice. Fortunately, today, in the morning, I was there in the E-Committee's National Conference, and today we have launched 5 different apps, and one of the Professor Dev probably pointed out, and the Modi Mr. Prashant Kumar also said, the effecting of service of notice itself becomes sometime in a judicial system a very big problem. And today we have launched an app. I think it will really going to have a dynamic change in the system where completely based on technology that notices will be issued. We have also launched a mobile app that will be available to all the members of the legal fraternity, members of the bar, the judges, the judicial officers, and that will have a composite facility of even tracking the issuance of notices, surveys, response, everything. So these are all the technological tools which I always believe that they can really be quite assisting the system. But of course, human judgment must remain at its core. The objective is to remove every avoidable obstacle between a legitimate claim and its fair resolution. The accomplishment of this goal depends on the collective resolve, and do appreciate that bench cannot realize it alone. It depends equally on whether the bar chooses to see itself as a worthy stakeholder in India's economic future or a mere service provider. That shift cannot be mandated by legislation or a court order. It must come as a matter of professional commitment, and the very fact that this conference has been convened, and I was just going through the theme document, the vision document which Mr. Prashant Kumar has kept for the conference, I really feel confident that there is a sea change in our professional approach, and the Bar Association as a lead group is really now concerned about developing and the culture of in the part of the profession where all the members can concentrate more in understanding the different complexities and the complicated issues of relating to the economy, and how the bar can then be a very constructive and a helping hand in ensuring that the courts also deliver the judgment, because that quality of assistance by the bar members largely has a reflection in our decision-making process. We have seen the evolution of resolution first jurisprudence under the Insolvency and Bankruptcy Code, which Professor Dev also referred to, from interventionist into an arbitration-friendly jurisdiction through a sustained line of judgments. These are all achievements, sometimes not by legislation alone, but by judiciary with the collaborative support of the bar members. These developments were shaped through sustained engagement between the bar and the bench. The next phase of commercial jurisprudence will require the same quality of effort, collaboration, and commitment between both sides, bar and bench. I can see some young lawyers also present here. To them, I would say, this not as an encouragement, but as a statement of fact. The generation that shapes India's commercial jurisprudence for a $10 trillion economy will be remembered the same way the generation that shaped its constitutional jurisprudence is hailed. The arguments that will define how Indian courts govern long-term commercial relationship and infrastructure commitments have yet to be made. I hope many of it comes from the young lawyers sitting in this room also. Let us remember the great jurist Roscoe Pound once observed that the law must be stable, yet it cannot remain static. That thought captures the tension of the present moment. The economy is evolving, commerce is becoming more complex, and the relationships that underpin it are asking something new of the law. The question is, how much prepared is our legal system to meet that demand? Dear friends, having seen the commitment with which all of us have approached this convention, I am confident that we will surely rise to the occasion. A $10 trillion Bharat will not be built by capital or policy alone. It will be built, in no small part, by the quality of the legal system that upholds the rule of law and the promises on which all of that depends. Our country never lacked the legal talent to build that system, and what this convention affirms is that it does not lack the will as well. I thank the Bar Association of India for having organized this conference, and I also wish these deliberations every success. I am quite sure we will reach to a definite conclusion that will help a lot to the bar, to the bench, and all stakeholders in ensuring that we have a robust legal system, a justice delivery system that helps India in achieving the most important object, the mission and the vision that the nation legitimately holds for itself. Thank you very much for inviting me. Thank you for giving this opportunity. Jai Hind, Jai Bharat.
Thank you, Your Lordship, for the inspiring and such a elucidating address for us. We are also grateful that from your busy schedule you have taken time out, because we know you have a packed day ahead, and yet you have taken time to address this convention. Now may I request our President-elect, Mr. Amarjit Singh Chandiok, to give his response.
Thank you, Bharat Sahib, Honorable Chief Justice of India, Justice Srikanth. My Lord Justice Arvind Kumar, the dignitaries on the dais, off the dais, office bearers, students, my dear friends at the bar. I think from what Prashant triggered today till my Lord has completed it, we have now a blueprint before us, how we have to develop this during the 2 days convention. I only wanted to remind, my Lord has stressed upon mediation, and I saw during a small conversation outside, Mr. Barry had said that the government has some illusion about mediation. I think it's time that if Mr. Barry can call mediators from various parts and probably get that illusion removed from the government, because mediation should be a first step that every dispute at every level must take. And if that is resolved there, relationship will remain restored. And I can only give him 2 examples of it. Time is short, I know, on which just he has to leave. One, that a divorced couple comes to a mediation table on a point of maintenance. What is the quantum? Because the typing error was there when the order was passed. And they go back married in the center itself. Now, this is only can be achieved in a mediation. I don't think any adjudicatory process can do it. The second was when 2 brothers were fighting, 41 cases on the board, and the mediator, which is nowhere in the mediation principles, went up because the elder one was elder to him also, touched his feet to say, I must respect you, you're elder to me. And that for some reason made the younger one stand, go to the elder one, and that was the end of the matter. 41 cases was only an annexure. The settlement was only 1 page. Now, this can only happen in mediation, and I think the stress by the Honorable Chief Justice that we should do it, the legislature must look at it, that whether they should make this compulsory now to look at, only Commercial Act will not help us. 2, I think the interplay between 2 statutes require reconsideration. And I think it's time that probably Bar Association should be invited before enacting any law to say, how do you iron out those things? I'm just giving one small example before I go, that Herrera Act also talks of a settlement, also talks of a plan, a resolution plan, and also is IBC. Now, how do you interplay with these 2? And especially mention has been made of the flat owners, home buyers. Now, that's where the conflict comes in. So I think like we should follow the Singapore principle, where before enacting any law, we must advise, call lawyers who are practicing in that field, also have legislature, and also have one honorable judge, so that you will get the views of everybody before the legislation is enacted. And I'm thinking the 2 days deliberations or guidelines that all our speakers have given will certainly thrash out and probably give a bigger picture of how, by legal reforms, amendments, legal reforms doing so, will be able to do it. My Lord's demand of bar coming to it, I can assure you on behalf of Bar Association of India, my Lord, we will stand right next to you whenever called to do anything which would help to iron out things, assist the road, and so far as the law students are concerned, I think time has come, and we have already started, my Lord, series of lectures at the law schools, even for the purpose of mediation. Thank you very much. I know my Lordship has to leave. And we look forward to a very, very deliberate, very in-depth discussion for times to come, for the 2 days. Thank you.
Thank you, Mr. Chandyok. Now may I request to conclude this inaugural session, our Treasurer, Mr. J.S. Maratha, to give vote of thanks.
Honorable Chief Justice, Honorable Mr. Justice Suryakant, the Chief Justice of India, Honorable Justice Arun Kumarji, Judge Supreme Court of India, distinguished guest of honor, Professor S. Mahendra Dev, Chairman, Economic Advisory Council to the Prime Minister, R. Venkatramani, Learned Attorney General for India, Mr. Suman Berry, Vice Chairperson, Niti Aayog, Mr. Prashant Kumar, President, Bharat of India, esteemed office bearers, distinguished members of the bar, member of the bench, respected delegates, ladies and gentlemen. It is my proud privilege and honor on behalf of the Association of India to propose the vote of thanks at the conclusion of this truly inspiring inaugural session of Bharat of India National Rule of Law Convention 2026. At the outset, I offer our deepest gratitude to our Honorable Chief Justice of India for gracing this convention with his august presence and for sharing profound thoughts that have set the tone for the deliberation ahead. His Lordship's vision on the role of law as a bedrock of national growth and institutional trust has enriched us. I express my sincere thanks to our guests of honor, Professor S. Mahendra Dev, for bringing an economist invaluable perspective on India's development journey. Mr. R. Venkatramani, Learned Attorney General for India, for his insightful reflections on constitutional governances and the rule of law. Mr. Suman Berry, for highlighting the crucial link between policy, institutions, and India's aspiration towards 10 trillion Bharat. My special thanks to Mr. Prashant Kumar, President of Bar Association, for articulating the theme legal reform roadmap to 10 trillion Bharat with clarity and conviction, and for envisioning this convention as a platform where law is recognized not merely as a profession but as an economic infrastructure essential to national transformation. I also place on record our appreciation for Mr. Amarjit Singh Chandok, President-elect BIA, for his thoughtful response, and Ms. Amar Singh Bedi for concluding the process and grace the precision. I extend heartfelt thanks to all our distinguished delegates, legal luminaries, members of the judiciary, policymakers, academicians, and members of the bar from across the country whose presence has made this gathering truly meaningful. This convention addresses an idea of immense national importance, that legal certainty, efficient dispute resolution, and institutional credibility are central to India's economic future. The conversation that begins today will, I'm sure, contribute significantly to shape a practical roadmap for reform and growth. Finally, I thank our organizing committee, volunteers, and every individual working behind the scene whose dedication has made this inaugural session a success. With these votes, I once again express my sincere gratitude to all our esteemed dignitaries and participants. Thank you very much. Jai Hind, Jai Bharat.
Thank you. With this, we conclude our inaugural session. And we are commencing with the first working session now without a break, and we'll try to conclude it as soon as possible after this. So thank you, and please stay back after our chief guest has left so that we can start our next session.
May I request Session Chair, Honorable Justice Arvind Kumar, Judge Supreme Court of India, kindly come on the dais and grace the working session 1. May I also request our Speaker of the session, Mr. Krishnan Venugopal, Senior Advocate, Supreme Court of India, Balbir Singh Ji, former Additional Solicitor General of India, Dr. Adit Sondhi, Senior Advocate, Supreme Court of India, Mr. Pratap Venugopal, Senior Advocate, Supreme Court of India, says Reporter Samrat Upadhyay. Kindly come on the dais and grace the session. Sir. May I request our session chair, Lordship, kindly.
A very good afternoon to all the participants, my esteemed co-panelists. As usual, like it happens in every other conference, the first session is always delayed, and so also the other sessions. So I will make it, because I will have to allow the other speakers, because it's almost 1:30. So if we detain you for, or depriving you of late lunch, we will be cursing. You will be cursing us. So to avoid that also, I will, instead of sticking to my written speech, I would like to highlight with regard to this rule of law, governance to problem-solving trust, moving from litigative governance to problem-solving trust, by giving you two illustrations from my own example. Number one, when I was Assistant Solicitor General in Karnataka High Court, one day there were about 69 matters listed before a particular judge, division bench. So the learned judges asked, Mr. Arvind, how many more cases are like this? I said, I will have to ascertain approximately around 200 cases. Then they said, we will adjourn this matter by 1 week, get us the entire list of cases, we will try to resolve it. And then to my shock, I found out it was around 390 cases. It is about land acquisition matters relating to Defence Estate Office, where a vast extent of land, thousands and thousands of acres were acquired for the sake of a defence project. And in few of the matters, the matter had ended before the apex court, it had reached finality. So the judges said, now that you have the index, you have the figure for determining the compensation, why don't you talk to your concerned officials and settle the dispute? So I contacted the Director of Defence Estate. Thereafterwards we had series of meetings, Joint Secretary, Under Secretaries and all, and we all came to a consensus that including the trial court matters, around 900 cases could be resolved at one stroke, as expressed by the Honorable Chief Justice through mediation, that is through Lok Adalat settlement. So everything was finalized, including the draft settlement. But ultimately the call had to be taken by the Secretary of the Government of India. So he came and we had a meeting in the judges' chambers. He said, I am sorry, sir, I will not sign. The judges were taken aback, including myself. We had spent nearly 2 months having series of meetings. And he said, sorry sir, I have got another 3 months, 27 days to go. I have an unblemished service record. The moment I sign this, the government will have to shell down around 1200 crores, 1200 crores. And next day I sign, the amount is released, I will receive a notice from Vigilance Department. I will not sign. The judges were furious. Ultimately, I had to take the brunt. That's a different issue. The thing is that mental setup or mental makeup of the government officials to settle the dispute was lacking, is lacking, will be lacking until and unless that change takes place. This is the first aspect which will have to prevent the litigation or to cut down the litigation. This is one aspect. The second aspect is what the Honorable Chief Justice said. The judge's mindset also should change. I will give you one small example. One day when I was sitting in the court at about 4 o'clock, still 45 minutes to go, I received a message from my PS saying that one of my cousins had expired and his cremation would take place before 6 o'clock. So I had to rise about 25 minutes early. So I telephoned to my wife, and my wife also had to come to the High Court. We were supposed to go to that place. And my registrar, admin, he came and said, sir, if you go in car, it will take at least 1 hour, 10 minutes. Then I said, what should I do then? He said, sir, can I make a suggestion? If you don't mind, can you go by metro train? I said, I would also like to go because I have never gone by metro train. When I was in Judge of Karnataka High Court, I said, I would also like to go. So I told my wife and we both went, and he said, sir, wherever you get down, I will have booked a Uber or Ola. I will give the OTP in your message. So you please give it. You can go to that place. By the time you finish everything, I will send the official car. You can come back. I thought it's a very good idea. And exactly 17 minutes I was at that metro station, got down, that Ola was there, I went, and after about 100 meters, there was a traffic jam. So slowly the vehicles were moving, 10 vehicles. I asked the driver, what is it? What is the problem? He said, sir, there is a bridge here. It is half constructed, and that is why they are leaving only 10 vehicles. So by the time our turn came, it was almost 15 to 20 minutes. During this interregnum time period, I had started a conversation with the driver. He said, sir, please see, sir, half-built bridge. Some idiot judge has granted a stay. Then my wife looked at me. I said, I have not granted this stay. Sir, from 2 years every day, this is what we are facing the problem. I cannot switch off the ignition. I'll have to keep moving slowly. And that he used many words, I would not like to repeat. He abused the court and judges like anything. What I'm saying is, look at from the perspective of, then when I came back, I asked the HUD secretary as to what is the problem through our Advocate General. I came to know later on that the contractor who was entrusted with the tender, he had abandoned the work and a new tender had been floated, and challenging that new tender, saying that it should not be given until and unless my bill is settled and I should be continued to execute this contract. He had obtained a stay of the entire tender process. And the government's effort twice or thrice to get the stay vacated has been in vain. And that is how it has not moved on. These are the two faces of the coin. So now how, from this litigative governance to problem-solving trust which we will have to create? I think my co-panelists will be throwing light on this. In conclusion, if required, I will refer to my prepared speech and share it with you. And because of lack of time, I hand over the mic to my co-panelists. I think Mr. Balbir Singh is the senior most.
But I don't mind quickly add this.
Okay, because looks are deceptive.
No, that comes from his father, I believe.
He's evergreen hero. He looks younger. So I think Krishnan Venugopal is senior than Balbir Singh.
Yes.
So I request Mr. Krishnan Venugopal to take the mantle further, wherever you are comfortable.
Honorable Justice Arvind Kumar, Mr. Balbir Singh, Dr. Sondi, distinguished colleagues, I was a little taken aback this afternoon because I thought my turn would start at 2:30, but apparently there was an email sent out which I didn't receive saying that ours would be the first session. Having said that, I would like to point out that this topic is at the intersection of law and economics. And economists and lawyers can really compete in terms of how much jargon they can use and how much confusion they can create between them. So I am often reminded of whenever I have to speak on a topic concerning economics, I'm often reminded of what President Harry Truman said. He said, every time you ask an economist to give you an answer to a problem, he will say first on the one hand and then on the other hand, and therefore I really need a one-armed economist who will give me a single answer. So that is the problem of economics. Now into that, you throw in the problem of jargon. When Mr. Prashant Kumar, a good friend of mine, asked me to speak on this topic, I looked at the note that preceded the session, and it had at least 14 different terms that I found involved a lot of jargon. Regulatory overload, litigative governance, problem-solving trust enhancement, proliferation of regulatory mandates, environment of compounding compliance burdens, regulatory excess, regulatory arbitrage, rewards of uncertainty over innovation, culture of litigative governance, managing risk rather than pursuing productive activity, reserve for unpredictable regulatory outcomes, inconsistent regulatory outcomes, architecture of trust-based governance. I must tell you I was bewildered by the time I came to the end of this session description as to what exactly we are supposed to speak about. But very broadly speaking, I think Justice Arvind Kumar has brought it down to its bottom line. The problem is that when you have too much of regulation, and in our constitutional scheme, you have a central government that is at the federal level, you have state governments, you have thereafter municipal governments, and then you have sectoral regulation thrown in as well. The problem, therefore, is that you have so many laws, rules, executive orders, circulars, that businesses don't know exactly what they are supposed to do when they start a business and when they continue their business. That, I think, is the essence of the problem in India. There are apparently 1,536 central acts in force in India as of last count, and that is without taking into account the thousands of state-level statutes, municipal bylaws, sectoral regulations, etc., etc. Now, India stood
while the ease of doing business index was still in vogue, India stood at 63 after a period of sustained reform during the current government's stint of the last 11 or 12 years. So we managed to move up to 63. But the reality is that as a business, if you want to start up any kind of new business, there is a huge number of laws and regulations and forms and approvals and permits that you need, which means that businesses will hesitate to initiate new businesses. The rule of law becomes a casualty when you have this kind of proliferation of regulation and regulatory statutes. The rule of law requires that you know exactly what laws you are subject to, what rules you are subject to, and that you be able to comply quickly and easily, and that after you think you have complied, there should be certainty in the outcome. That is an application of the rule of law to what businesses currently face when they do business. The rule of law, according to the Supreme Court, is about non-arbitrariness. And if businesses don't know exactly what they're supposed to comply with and how after they comply they will be treated, then arbitrariness creeps in. That is the problem that we are facing. Now, I'd like to take you to certain other aspects of the rule of law and economic activity. One of them is regulatory overload. When you have huge numbers of rules and regulations, you also need the institutional capacity to actually administer them. Now, our problem in India is that we don't really have the institutional capacity to actually administer all the rules that one must comply with in a way that makes sense. So, from that standpoint, the rule of law demands that laws be general and prospective, that they be noble and accessible, and that they be enforced consistently and proportionately. In other words, these are the minimum requirements that all of us would require if we are to do business in India. When there is regulatory excess, as is currently the position in India, then you cannot comply and you have arbitrariness. Now, I'd like to give you an example from my own experience in, as a counsel practicing in the area of environmental law. Whether you are starting a mining project or a large industrial project, you need clearances at multiple levels from the government. Actually, it's plural, governments. So, you need usually an environmental clearance if it is a project of any consequence whatsoever. That environmental clearance frequently is accompanied by a forest clearance. And then at the third level, you need a pollution control board clearance, first as a consent to establish and then as a consent to operate. Now, in my experience, most projects will be able to get the environmental clearance fairly quickly, though it takes time. On the other hand, the forest clearance involves significant coordination between the center and the state, because we are a federal polity after all, and it is done in stages. Now, as part of the forest clearance, you have to do something called compensatory afforestation. and that compensatory afforestation requires you to get land. In most states, you have to acquire the land yourself, which is next to impossible in many of them. You need land which is not forest land. You need land that is revenue land that can be converted into forest land. That adds a huge amount of expense if you want to do the project. And in some states like Jharkhand, it is simply impossible to find forest land. Now, in the state of Jharkhand, you have the Chota Nagpur tenancy laws, which emphasize that tribals have priority over everybody else in terms of their ownership of land, and that you cannot take away the land from tribals. So Jharkhand, being one of the poorer states of the country, but also one of the most mineral-rich states, is caught between a rock and a hard place because industrialists can't find the land that they need in order to start a project in a state like Jharkhand that offers all those mineral resources. So ideally, the Ministry of Environment, which administers the forest clearance, ought to have figured out a solution whereby you could do the compensatory afforestation in some other state where land is more easily available, or simply taken money instead. But that is not the way that they do it. They insist that you must find the land in Jharkhand. So this is an example of how overlapping regulation between center, state, and even sometimes at the municipal level and at the sectoral level will conflict. Then there is the concept of regulatory arbitrage. That is, businesses that know how to exploit the various kinds of regulations in a sector, like for example in real estate, can often defeat the rights of home buyers. Let me give you an example again that I came across in my own practice, and it is still at large in the court, so I'm not going to give you details of names, etc. There were two real estate companies that entered into a joint development agreement for a real estate project in an urban area. Under this, the first company had to pay a significant amount of money, running into hundreds of crores, for the development right over the land which was owned by the second company. The license, the development license for the land, was in the name of the landowning company. The landowning company gave a power of attorney to the first company to sell 65% of the flats, which was its share, to the constructing company, that is the development company, and allowed them therefore to go ahead and sell these flats in order to raise the cost for construction. The development company therefore took a huge amount of money in running into hundreds of crores, almost 1,000 crores from these home buyers, and started the construction of 3 phases of this project, developed, let us say, yes, I will try to complete this after this example. So they completed a significant proportion of the construction of each of these phases, and then siphoned off the remaining money into their own accounts and other projects. Thereafter, they started a collusive IBC proceeding in which they sought to put the whole project into insolvency. The landowning company now realized it was on the hook because it had signed the apartment buyers agreement, based also on the power of attorney that it had given to the development company. They went to the RERA and confirmed that they would in fact finish construction and give flats to all buyers of both companies. The 65% to the development company's buyers and the 35% flats to its own buyers. Thereafter, they went to the IBC and they managed to take over the IRP, who had been put in place by the NCLT. That IRP, who was in their pocket, now started telling the home buyers, you will only get money, not flats. That is, the development companies' home buyers would get only money and not flats. Thereafter, they ensured that a PMLA proceeding was started against the development companies' promoters, and they identified various assets of the original promoters of the development company. They went to the PMLA court, got the IRP to file an undertaking for which there's a standard format, saying that he will take over those assets and distribute the money to the home buyers. Then they went to a writ court in two separate proceedings, and in the writ court they got an order from one judge by way of an interim order in a writ petition filed to initiate investigation of the promoters of the development company. They filed an interim application and got orders from the learned single judge that no proceedings would be permitted by the home buyers of this development company to get anything other than money, and that they would be only entitled to money and not flats. They also got an order restraining the RERA of that state from proceeding for giving flats as per the original understanding. Then after the PMLA court passed an order affirming the IRP's right to take over these assets, they went to a second writ judge and got another order saying that home buyers would be entitled only to money, and the PMLA court's order would be enforced as against everybody and third parties, including all statutory tribunals, etc., so that the NCLT's hands would also be tied. So the point I'm making is that when you have multiple authorities, and of course there are NCDRC cases as well, they went to the Supreme Court and got a settlement between one home buyer of the development company and the IRP that he would accept only money. And this was also sought to be enforced through the two writ court orders. So this shows you what can happen when there are multiple mandates in a single sphere of economic activity such as real estate. You have the RERA, you have the IBC, you have the writ court, and you have the NCDRC. And using all of these and the gaps between the various regulatory regimes, they managed to take away the rights of the home buyers of the development company. So my point to you is, this is exactly what the rule of law should not permit. When you have multiple overlapping regulatory mandates, it can also be misused. And with that, I will end my talk. Thank you so much.
Thank you, Mr. Krishnan Venugopal. You have touched upon too much of regulations create doubts in the mind of the business houses, too much of forms, too much of regulations, and about the rule of law. Before I hand over the mic to the next co-panelist, I would like to just share with you, once when I was sitting in Dharwad bench, a writ petition came where an application for establishing a nursing home was rejected. So I asked, what is the reason? The reason given was, washrooms of male and female are adjacent to each other, next to each other. So then where should they be? No, it says, the rule says, separate and distinct. So that means it should be this corner and that corner. I said, what is this? So we said, all right, we will overrule that. Then what? Then he said, sir, still we can't give it. Why? Sir, in form number H, the annexures, small signatures, chota signature has been done, it should be full signature. Then all right, we will overrule that also. We will ask him to put the signature. Get your file, we will ask the parties present, 2:30 we will take up, we will sign it. Then what else you can have? Sir, he has put for so-and-so hospital, he has not put the designation. And I said, all right, you put that, whatever, director or managing director, whatever, you put it. Then he said, sir, everything is okay, now that form itself will have to be changed. I said, why? Sir, he has signed in blue ink, it should be black ink. This is the bureaucratic approach many a times. And that hospital, they have invested more than, I think, about at that time 40 crores or something. So, sir, after investing 40 crores, I go with this before the second division clerk, and he says, you put blue ink, green ink. I am ready to, do not want to open the hospital itself. This will be the mindset of the people. So, the people who govern the administration, they should be alive to the actual position. Like in a case of litigation, when the party comes, if you tell him, see, the judge is unable to understand the issue of necessiter saucis, he will say, sir, I do not know. Mujhe bolo, hamara case jeeta hai ya hara hai. That's all. That is what he wants. And this is what the people also expect from the people governing, including the administration of law. So this has to be simplified, and it is to be easy and not monotonous. With this, I hand over the mic to my co-panelist, Mr. Balbir Singh.
You can text from here. Thank you very much for having this afternoon. I think because of the change in the timing in the first session has taken time, possibly we all of us cannot adhere to the whatever the timelines or the scheme we had planned. But since we understand the topic of the regulation and economy, what we have seen, and the objects is we are looking at a $10 trillion economy. I'll just refer to a book which is called Breakneck. It's a recently released book after Chinese Premier and Donald Trump, both the cabinet and Politburo meeting in China in late last year. It's called Breakneck, written by Dan Wong. So what the theme of the book is, the governance by lawyers and the governance by engineers. And the context was that since last 4 decades, the Politburo, Chinese Politburo has largely been dominated by engineers. And I never knew that Chinese Premier Xi Jinping is a chemical engineer. So the context was the infrastructure which has been created in last 4 decades in China is primarily a governance by engineers. Contrasting that with the US infrastructure in last 3-4 decades, the infrastructure is completely in shambles as on today when we look at purely from the infrastructural standpoint. I'm not on the institutions, because infrastructure and institution play a very significant role in a GDP and growth of any country. The numbers can vary from how much they contribute to each other, but it's a very good analysis which have been given in that book. When we look at the first thing is of any country, when we look at how the country is to be shaped, is how the country is being governed and the kind of people the country is being governed is the first fundamental factor. And I give 2 quick classic examples in last 3 months of the role by judiciary and role by the in governance through a regulatory mechanism. In 1991, India was capital-starved country. Today it is, because I don't think the domestic capital is good enough for produce the numbers what we are looking at from the point of a growth we are looking at. 1991, India was capital-starved country. Therefore, multiple double taxation arrangements were entered into, the largest being India, Mauritius, and said that you invest, we'll not ask you. If the Mauritian government is giving you a residency certificate, we'll not look at it. Government of India defended this position when in a PIL which was filed before Delhi High Court, Government of India said that no, we don't question, and our objective is if the Mauritian residency is there, we'll not look at it. Come 2017, the government says that we will, post 2017, we'll inquire about from where the capital is coming into Mauritius and then coming into India, no problem at all. We had 4-5 months back a decision by the Supreme Court where the policy decision was taken, argued that we can apply the anti-avoidance mechanism check, which means that whether there is in the entire scheme there is an evasion mechanism or not, and we'll go behind, we don't honor the residency certificate given by Mauritius. Therefore, that matter, and this was one of the largest, the money which is coming into India in terms of investment is Mauritius. So in that case, it has created a furor because there is no differentiation of pre and post 17, and since I have at some stage in the part of the funds and all these things, what I have seen in last 4 months, the kind of uncertainties has created beside the external factors among the investors in India, and these investments are large size investments in India in the very, very significant domestic sectors. Come this month, a new income tax rules have been placed, where the rules very clearly says that pre-2017 investment, we will not look at it. So when we look at the uncertainty of this nature, judiciary has played its own role, because that's the position which was pitched by Government of India. So if you look at it, if in the new rules which are implemented from 1st of April, this position was clear that we don't want to touch pre-2017. There is no need for this position to be taken in the litigations which are going before the court. So what I see is in the execution, the policies framed or the regulatory environment which is being framed and represented, I think there is certainly some gap. That's one aspect which I'm noting, where the judiciary's role came in. And it's got a massive impact on the growth of GDP and inviting capital to the country. Second thing which has happened in last 3-1 months, which is pure regulatory, is that online gaming has been completely banned. Look, online gaming was in a vague situation, in a grey situation in last 4 years, and we had a very, very serious amount of investment in that sector. Very large private equity investors invested in the new startups in the country, created a very big job. I'm not denying this can have a social impact, and government can certainly look into it. But the decision was so abrupt that all large gaming companies which were spending huge investment in the country, which were creating jobs in the country, were shut down. Interestingly, in last 3-4, if you see New York Times, if you see Indian economic newspapers, all the gaming companies are operating offshore today. Only the payment mechanism have been shifted. Not the revenue which was coming is coming to the country, but still it is being played. This is the regulatory uncertainty which I talk of, not even having any link with when we look at the $10 trillion economy we are looking at. These are the decisions which should not be taken. These are not the areas where the regulators, when they think, there can be a certainly objective to be achieved. And I think the largest factor which is going to be for making the Indian economy as a 10 trillion economy is a technology. As on today, I don't think there is a clear regulatory regime we have on a technology space, multiple aspects on it, which is going to be the capital creation for the country which is going to go on. So this is what I'm talking of, the governance part. So 1A at a policy level, 2 at a governance level, unless these things are very, very clear. These are the new generation areas. Everybody knows that the large economy growth is going to come from these areas. These can't be done. Today we live in a world which is very, very uncertain, because any country's growth, if somebody presumes that we can have 12% GDP for next 20 years, and then we look at that's the maths which I understand in the morning some economists gave, that if we achieve 12+% GDP growth in next 20 years, we'll be 10 trillion. But to consistently go for 12% GDP growth in 20 years means lot of certainty, lot of vision, and lot of execution. And when it comes to the execution of these policies, I think the biggest gap is a bureaucratic gap. The policy may speak one language, but when it comes to policies, these to be implemented, I think that's where the India's failure I see, which has taken place. And one of the classic example is the environment. Another example I give, because since these matters we see every time in Supreme Court, we can be either this side, that side. Rare earth mineral, nobody realized 20 years back this is going to be so prominent, because today in the role of mode of transportation which is to be played, that's in every chip manufacturing which is used in the transportation facilities requires rare earth. China started processing it 15 years back, and therefore they are leaders today. 90% of the rare earth is controlled by them. Remaining 10% come from the other countries. They also give them process to China to process that. The reason is that we don't want it in my backyard, because a dirty job to be done in a developing country, and therefore I'll not do it. Today the Europe and US are dependent on completely, because they do not have created a processing facility for whatever they have. And they have not made investment in these areas where the rare earth mineral can be processed, because processing is very expensive. Again, this is a conflict between the position to be taken on R&D and investments to be made in the new generation areas, to how much and how far, again a policy issue, that on the name of the environment, the economic decisions are to be let go. That's again a policy decision, because unless the environment process is very clear and clean, if it is clear, it should not be taken. We have for last 25 years, the Supreme Court has been monitoring every project is going to Supreme Court to examine that it is to be approved or not approved. We dabble with these applications on every day, look at the kind of area we are talking of. Again, it's a part of governance. Why can't there be a clarity on an area of this nature rather than struggling in the court to say that ultimately the objective is 10 trillion? The job is, I think the one part is the bureaucrats and the policy makers need to be very clear what decision they want to take and what laws they make so that the court can also be clear and they can take a decision on what the law given by the parliament to them. Good faith principle applies at both the aspects, what we have, and I think I must congratulate Prashant. The base document which has been prepared is a very, very good document which he has prepared. I had a look into the document. But broadly, I think since this time is short, when we look at these aspects, a clear law, clear policy, and a clear implementation through the system which has been created, and then the enforcement mechanism should be clear. The enforcement mechanism today, if we see the sectoral regulator in our country, be a oil and gas, be a competition, be a IBC, all these are the tribunals which are manned by people from various areas which are being done. They are there for 4 years. These kind of tribunals cannot be manned unless you create an expertise, and expertise is created over a period of time. These are big points which are very straight and simple, and unless these are the areas which are to be looked into and a clear decision is taken on these aspects, the 10 trillion, 12% growth for 20 years, I think we have talked for last 20 years on these numbers are not real. And these are the certain steps to be taken at the highest level that these are to be determined. And these are if you make the certain maths on certain aspects, this clearly gives why the number has not converted. Today to say that we do not have the facilities of even parking these, if God forbids that when we see a geopolitical situation which is going on, we do not have enough hangars to park even the aircrafts today for if something is to be shot. So that's where the China's comparison came, and the book gives a very, very concrete example. There was a doubt in the minds of the executors there or the policy makers there at that point of time. Are we investing in a right space? Over a time, they created an infrastructure which was thought it was a glut. But these are a decision which, to my mind, regulation in sync with law is something which is required today at a broader level. What I see is there is an example in the world where we see that this is the way forward to it.
Thank you, Mr. Balbir Singh. By your erudite reasoning, you have succinctly explained the importance of governance by lawyers and engineers, about investments by the corporation, and comparing it with the statistics of other countries in comparison to India, and the wide gap that exists between the policy and the regulatory mechanism, and about the uncertainty. And the next speaker would be Mr. Pratap Venugopal. Okay, Aditya Sun. Okay, whoever is senior. We'll follow that. Mr. Pratap will share his thoughts, and my request to the other two speakers is I will have to go at 2:30 to that arbitration council to deliver one more lecture. So I request Mr. Pratap to conclude it, if possible, within 10 minutes. Thank you.
Honorable Mr. Justice Arvind Kumar, Judge, Supreme Court of India and Chair of today's session, distinguished guests, distinguished colleagues at the bar, ladies and gentlemen. Let me begin with the proposition that concerns Indian entrepreneurs and investors, namely the quality of our legal and regulatory environment directly affects business operations and investment decisions. Too often the domestic business environment is built on suspicion instead of trust. This limits productivity, discourages new ventures, and leads to underinvestment. In turn, it slows economic growth and innovation. The central argument is not that deregulation fuels economic growth, but that intelligent regulation does. Clear, consistent, contestable, and proportionate regulations are essential. Only then can we ensure legal certainty while fostering economic development. But today the challenge is not merely the absence of good regulation. It is the excess, fragmentation, and unpredictability of it. Multiple authorities, overlapping jurisdictions, and shifting compliance standards create what business experiences as regulatory overload. So the rule of law demands not more rules, but better rules, fewer, clearer, and consistently applied. Indian commentary calls it the rule of statutes and norms, not the rule of men. It insists on an optimum balance of power between rulers and ruled, grounded in liberty, due process, equality, and transparency. Our Supreme Court affirms that arbitrariness opposes equality and that legitimate power cannot be arbitrary or stray from reason. In 1973, in E.P. Royappa versus State of Tamil Nadu, the Supreme Court held that arbitrariness is the antithesis of equality. In 1978, in Maneka Gandhi versus Union of India, fairness, reasonableness, and due process were elevated as constitutional requirements. And in 2017, in Shayara Banu versus Union of India, Supreme Court reaffirmed that manifest arbitrariness invalidates the law itself. But the rule of law is not sustained by courts alone. It is sustained by the conduct of choices and conscience of the bar. Every pleading we draft or settle, every adjournment we seek, every appeal we advise, shapes not just outcomes, but the credibility of the legal system itself. Today, I suggest this. The rule of law is India's most valuable economic asset, and the bar is its most immediate guardian. Not regulators, not policymakers, not even courts in isolation, but lawyers who translate law into action. If the law becomes uncertain, it is not always because statutes are unclear. It is often because practice becomes unpredictable. Certainty in law stems not from judgments alone, but from our practice. It is created when advice is candid, strategy is responsible, and litigation is not used as a delaying tactic. The bar shapes how the system works and how it is perceived. We often attribute delay to systemic backlog, but let us reflect honestly on adjournments, procedural maneuvers, and routine appeals. These are not abstract forces. They are choices made at the bar. In 1979, in a landmark decision in Husainara Khatun versus State of Bihar, the Supreme Court recognized the right to speedy justice. So when delay is prolonged, it is not merely inefficiency, it is a constitutional compromise. Now, a significant portion of litigation is driven by the state. But who advises the state? We do. Are we enabling or restraining the state's litigation? The duty of counsel is not merely to win, it is to prevent unnecessary litigation. In commercial disputes, the bar's role is even more direct. In 2012, in Balco versus Kaiser Aluminium Technical Services and subsequent decisions, the Supreme Court has consistently limited judicial interference. But whether arbitration succeeds or fails depends on how lawyers conduct it. Do we streamline issues or multiply them? Do we seek resolution or prolong proceedings? Efficient dispute resolution is not just a legislative goal, it's a professional ethic. Now, regulatory reform today is moving towards proportionality as recognized in 2016 in Modern Dental College versus State of Madhya Pradesh. But proportional regulation also requires proportionate legal advice. Clients often ask, can we challenge this? The better question we must answer is, should we? In 1992, in Navjyoti Cooperative Group Housing Society versus Union of India, Supreme Court recognized the doctrine of legitimate expectation. That doctrine applies not only to the state, but to the legal system as a whole. Clients expect honesty in advice, efficiency in process, and integrity in conduct. Ultimately, economic growth depends not merely on legal correctness, but on institutional trust. Trust that regulation will be fair, trust that disputes will be resolved efficiently, trust that the state will act predictably, and trust is built daily by the conduct of the bar. Let me now conclude with this thought. In the 1973 landmark case, in Keshavananda Bharati versus State of Kerala, the rule of law was recognized as part of the Constitution's basic structure. But constitutions do not enforce themselves. Courts cannot function in isolation. The rule of law ultimately lives or fails through the bar. If arbitrariness is the enemy of equality, the question is not what the state does. The question is, what do we tolerate? Fewer cases that should never be filed, faster resolution of those that must, and absolute integrity in both. Because the rule of law is not only argued at the bar, it is defined by it. Thank you.
Thank you, Mr. Pratap Venugopal. You have explained the nuances of legal, the economic growth depends upon the investment, and investment depends upon the legal environment which is created. You have also explained succinctly about the arbitrariness which would invalidate the law, and law should not become uncertain, and about the large part of the litigation relates to the state. At the time of concluding, I will say a few words on this. And now I request Mr. Aditya Sondi, whom I can say that Dr. Aditya Sondi, that loss of bench is the gain of the bar. I'll tell you one day as to why.
Thank you very much, Justice Arvind Kumar. My esteemed colleagues on stage, Mr. Naganand, Mr. Diwan, Mr. Prashant Kumar, Mr. Bedi, ladies and gentlemen. I believe I have to play a T20 innings. Mukesh ji has told me 5 minutes and no more. I want to address this topic from the trust deficit angle. If we look at the developments with the Iran war, to use a loose metaphor, the war was litigation and the mediation was peace. But with the mediation comes the requirement of trust. And no mediation can succeed in the absence of trust. So from the perspective of the topic, I try to think of where the trust deficit emanates from when we look at this regulatory overdose with which we function. One is, I think, in the very description of regulators as regulators. The moment you ask an institution to be a regulator, its intuitive tendency is to either prohibit or restrict or to regulate. Why don't we imagine them as promoters? Promoters in sectors can also be regulators, but just a nomenclature change is not what I'm espousing. What I'm saying is we need to have an attitude by which regulators in fact see themselves as sectoral promoters. And once that's the case, then I think the communication and the trust increases. But where we are today, this overdose, I'm afraid, is there to see. I'll give you two quick examples from my own experience. One is a matter, in fact, where my friend Pratap is on the other side for SEBI, a formidable regulator. I can't say much because the matter is sub judice in the Supreme Court. But this was a case where a party went to the High Court seeking reduction in share capital. But unfortunately, it was a listed company. And once you're listed, there's no escaping SEBI. And the short question as to who exercises jurisdiction in matters of reduction of share capital, is it the High Court under the old Companies Act, which also acts as a regulator in these non-contentious matters, or is it SEBI, is a dispute that has transcended different benches of the High Court multiple times. It went to SAT, and now there are multiple appeals pending in the Supreme Court. In fact, some of the judges we began these cases before are now happily into their retirement. The other instance is one relating to Bitcoin. And in the early days of Bitcoin, there was an enterprising chap in Bangalore who set up a Bitcoin machine at a mall. And he said, I'm going to now hand out Bitcoins. Of course, he never even operated that machine. And this was a complete regulatory vacuum because at that point, the sector was not even abreast with what Bitcoin meant. And the Bangalore police jumped the gun, not only seized the machine from the mall, it also registered an FIR alleging cheating. And we had to have that case. Are going to be two burning questions with which we grapple. How much scope do you permit to these sectors? How much do you regulate? I think is going to be an issue. From the Bitcoin precedent itself, I think many of you are aware, the RBI at one point had practically prohibited Bitcoin. It was struck down by the Supreme Court saying it's disproportional. And then slowly it had to roll back on this front. I think also on trust deficit, if we speak of the concept of regulation, we cannot detach it from the ills of tribunalization. And my friend Balbir made a passing reference to tribunals. The trust deficit in the minds of investors, startups, etc., relates not just to the initial regulation from the sectoral regulator, it also transcends to the roles of the tribunals that oversee almost each of these sectors, right? Be it electricity, be it NGT, right? Be it the consumer fora, wherever you look at, there is a tribunal interface that comes in, environment. So, in this sense, any reform that we think of has to take into account the reform with tribunalization. I don't have time to go into that. We know what those ills are, but that is the elephant in the room that has to be addressed in this regard. I want to also say here that we need to look at instances of no regulation or self-regulation when we reflect on this topic. Look at the media in India. It's practically unregulated or self-regulated, which is really, I think, another word for saying unregulated as far as the Indian media is concerned. Much was said about the role of the bar in growing India towards this $10 trillion economy. Now, the bar is also a self-regulated body. Of course, we are regulated at least under statute, unlike the media. But we need to reflect then on the outcomes of regulations of our own profession if we are going to look at ourselves as serious players in this realm of achieving this ideal. Finally, I think there was this practice of going to advanced ruling authorities, at least in taxing statutes. I think that was a welcome sort of pointer to preempt litigation in many cases. Not that it did, but this idea of having preemptory advanced rulings, especially in more contentious, high investment sectors, I think is something we need to reimagine, a sort of single window clearance on all fronts. The CCI is doing that in terms of merger controls and so on, but I don't know how far that is achieving the end, because even with the CCI many times, it overlaps with other institutions and other regulators, which makes the plot even thicker. You now have the Jan Vishwas bill, which is trying to reduce offenses and make ease of business more of a reality, but I don't know how much that can achieve. Finally, let me say, friends, that when we speak of rule of law, and my friend Pratap, I think, very eloquently spoke about the concept in the short time that he had, this emphasis on rule of law being dependent only on the other, I think, has to change. You can't only look at courts and institutions and say rule of law belongs there. I think private sector also needs to imbibe the spirit of rule of law. More transparency, more equity, and more fairness in your own business practices and the manner in which you approach investment, I think, will also define this ideal of rule of law. I'll stop here. Thank you.
Thank you, Dr. Aditya Sondi. You have explained about the self-imposition of rule of law by all persons, apart from explaining about the trust deficiency and where it occurs and how it has to be overcome. And you have suggested, instead of regulator, promoter, it's a very good idea, where by mere change of nomenclature would not be sufficient, but you would require there is a change in the attitude of the persons who would be regulating these regulations. You have also said about over-regulating has to be stopped, and in future about the about the AI being one of the contentious issue. In fact, that would be a good hunting ground for the lawyers. Sometimes, many a times it is said, there are certain litigations which are lawyer friendly, so you cannot avoid it. But for the statistical purposes, I would like to state 3 ministries, that is Ministry of Finance and Ministry of Defense and Ministry of Railways. You know, Ministry of Defense, Ministry of Finance has 1.89 lakh cases pending. Ministry of Railways has got 1.14 lakh cases. Ministry of Defense has got 95,467 cases. And friends, I can tell you, by my little experience of 19 years and above, if these litigations are gone for mediation or lok adalat, 50% of them can be settled across the table. 50%. For this, the mindset of the private litigant is always willing to settle the dispute. It is the governmental officials and governmental machinery that their mindset they have to change. And for that, it requires the support of the people who govern. Until and unless that such support is forthcoming, it will be very difficult for even for the bureaucrats and the officials to take a call on this. And before I conclude, I would thank my co-panelists for sharing their thoughts, and we hope that this Chintan and Manthan would rebuild the trust and good faith as a legal infrastructure and provide a gateway for improving the system for resolution of the disputes. Thank you very much.
Thanks, my lord. Thank you, my lord, for valuable suggestion and views for rule of law as a pillar of economic growth. And my lord has given well and commendable suggestion. I thanks on behalf of the Bar Association of India and my on behalf to Justice Arvind Kumar, Judge Supreme Court of India, and learned speaker Sri Krishnan Venugopal, Senior Advocate, Mr. Balveer Singh, former Additional Solicitor General of India, Dr. Adit Sondhi, Senior Advocate, Mr. Pratap Venugopal, Senior Advocate, for his valuable views and suggestion for making rule of law as a economic growth. Thanks, my lord.
I know we are already running late, so I can only request if we can have a quick lunch. Yeah, if we can wrap up in maybe 30-35 minutes.
शुक्ला जी। notes or what you get here and there in books people written as autobiographies. The truth lies somewhere in between. It's not exactly the way you see it. It's rather gray area. I'll tell you why I mentioned those 3 dates and why it mattered. You may recall that India was completely open in 1947. It was the 1956 Act which shut down India, the Industrial Act of 1956. And then, following almost 21 years later, was a period when Mr. Fernandez became the Minister for Industry, and he shut down everything by asking all foreign companies to leave India unless they downsized their investment to 40% equity, which was neither here nor there, with no particular guardrails on how to protect your 100-year-old investment in the country. Consequently, most people of any reputation left India quietly. They didn't make a noise. The company I was then working with also left India in 1977. But 3 years later, out of sheer need to look at India all over again, started doing so. And here I was, at the instruction of the chairman of a giant Fortune 500, it was actually #1 in the world at that time, to say, can we do business in India? And therein started a story. Now I will tell you an anecdote which may surprise you in a way. We had looked at doing business in many areas, aircraft engines, gas turbines, power plants, all the regular things. But then we had an Indian public sector undertaking called IPCL come to us and say, create a joint venture. It took me a year of convincing my company that the government could make a good partner. You can imagine with all the baggage, my promoting that idea. And we went ahead, we negotiated, we settled. And then came the googly. The googly came by the wife of the chairman, Mr. Jack Welch, when she said to him, I'm not allowing you to travel to India to do any deal. Why? They arrest American chairman on arrival. The year was 1984, as you can imagine. Union Carbide, Warren Anderson's wife, and Jack Welch's wife were friends. So it is not we were fighting the law of India, we were fighting perception, as you can imagine. So what was my instruction? My instruction was, I will travel to India provided my general counsel, Mr. Ben Heinemann Jr., who is a former Supreme Court lawyer, whose father had been a judge of the Supreme Court of the US, quietly travels to India, and you prove to him that India is a country of law. So here I am scratching my head. How do we do that? Luckily, with good relations at that time with a bunch of Indian Supreme Court senior advocates, the date we chose was Mr. Fali Nariman representing Union Carbide, and the argument was against him from Mr. Shanti Bhushan, and the judge in a 9-man bench, Chief Justice of India, the Honorable Sabyasachi Mukherjee. So me, much younger version of me, walks into the Supreme Court of India, court #1, sits with Ben Heinemann right there in the front row, and we stare at the way they do business in the Supreme Court of India. 30 to 45 minutes later, when it was all over, on the way out, down the steps, Ben puts his arms around my shoulders and he says, my pet name is Sunny, he says, Sunny, I think we can work here. They seem to be a country of law. They are very quaint Supreme Court, unlike ours. But I think we can do business here. That actually, ladies and gentlemen, opened a floodgate of additional investment, and the rest, as I say, is history, with giant GE companies here, many of them surviving till today, huge employment, etc., being created. The other thing we learned along the way, it is not the community in this room. You're all friends. I mean, you actually aim at getting stuff completed, done, closed. The people I met normally came out of a Missouri academy. Very longish name, LBSNAA. And when I would meet them, the learning I got out of that was the following. There is a bill proposed in Parliament. Let's say the Nuclear Civil Liability Damages Act. The bill is proposed. It has gone through. Very little consultative process. No discussion with industry, mostly internal. A bit of argument in the Lok Sabha. Bill is through. Now it's got to be enacted into law. Who writes the rules and the Gazette notification thereafter? The hands through which it passes. And the way that bill, by the time it's become an act, and the rules by which we have to work are mangled on the whimsy of people coming out of very serious academies. And we are surprised as foreigners, foreign company, saying, what happened? We looked at this, but we are getting that. And then you have to wade through many of my prior speakers have already said these things. I won't have to repeat it. The Chief Justice himself said it earlier in the morning. I won't repeat it. It's there that to borrow a euphemism, that's where the rubber hits the road. The interpretation of an act, business being done in good faith, as my good friend Mr. Prashant Kumar has used the term in the morning, in good faith, you go in, you deal with it, and you do the contracts, and then you discover the animals hiding in the jungle. And that jungle doesn't reveal itself till after you have invested. Then you come up with great constructions which are entirely Indian. Retrospective enactments. Retrospective, excuse me, sir, I made $1 billion investment. Now you want to claw something back from me because I made the mistake of doing that? Sorry, but that's the way the legislature works. Retrospective. The other one, which is more recent, something called a press note. Out of the blue, you'll be merrily going along doing business, and there will be a press note which will come up. And the press note will say, you are now not allowed to do this or that. Actually, believe me, I've had an army of people sitting in my office continuously, poring over every notification of every government of the state of India to make sure that we remain within the straight and narrow, because we would operate in every state of India. My biggest customers were the government of India or the state governments of India. I will wrap it up. I think I've communicated my message. The message is this. Insofar as structuring of the law is concerned and its actual operations are concerned, I'll just go back to my notes because I made a simple little 3-word structure here. And I'll read it out to you. In the boardroom, what is it we look for? We look for 3 things. We look for volume. I'll explain volume. Volume is that when I'm putting $1 billion factory, I need to recover my investment. That volume of business I must do. Government secretaries have actually said to me, but that's risk capital. I said, I'm risking it on you, the country of India. Yes, I know that, eyes open. But then allow me, make sure that I have visibility, that I can produce the volume. Visibility, that means I've explained to you it takes me 8 years to recover. Kindly, even if it's a bad law, keep the bad law in place for 8 years so we know our guardrails. Don't change things in between and make it difficult for us. Certainty. Now that everybody argues against. No, it's we're a democracy, we can't have certainty, we have changes, we have political parties come and go, etc., etc. No, sir. Certainty simply means that if I'm abiding by the law, kindly ensure that you allow me to continue with certainty to do the things I set out to do. And the last one, continuity. This one, I'll tell you what it means. In the 80s, when I used to go around the world, asking my colleagues to invest in India, within the company and outside the company, I would very proudly stand up in front of a large audience and say, no matter governments in India change hands, one to the next, the rule of law continues, and if we have signed contracts with the prior government, it will continue and will be honored. Unfortunately, I don't need to say too much, that has also somewhat drifted. Now, if you've captured everything I've said, imagine the things which need to be done. Mr. Prashant Kumar in the morning already said it. My colleagues here are about to say it. And I would say that if you capture those things and actually focus your attention on the execution part with the academy in Missouri and all the people who come out of there and get them educated on the institutional mechanism, what it takes to keep investment grounded, a great service would have been done. Thank you.
Thank you, Mr. Sharma. I think the industry experience is very, very enlightening, and the battle of the image that we project is very important, and I think it has substantially changed. I think today India is viewed as an investment destination, and I hope that we improve. Now, may I request Mr. Shyam Diwan to deal with this perspective also.
Thank you very much, Mr. Vaidyanathan, distinguished members of the panel, ladies and gentlemen, a very good afternoon to all of you. I was, first and foremost, completely not able to comprehend as to what 10 trillion US dollars was. I mean, how big is this? How ginormous is this? And I turned to Piet Hein, the Danish mathematician and physicist who used to occasionally write these small poems, which he called Gruks. And since the Danes were probably not on this subcontinent as a colonial power, I felt it safe in this hyper-nationalistic time to quote from Piet Hein his Gruk titled Budgeting the First Law. And this is how it goes. If you want to know where your money went, you must spend it quickly before it's spent. So taking a leaf from that, spend the money, be careful about how you spend your money or spend it right away. How are we going to reach this whole notion of a $10 trillion economy? And there were a huge number of hints and suggestions which were made in the morning session. I plan to build on them and respond to some of the points which were made here as well. But first, I thought I should just set a couple of ground rules as to where are we today. I think many of you would have come across the World Justice Project, and it comes out with a rule of law index. The 2025 index ranked India at 86 out of 143 countries and jurisdictions. 68% of the countries overall declined in the rule of law scores of 2025. It was the steepest, amongst the steepest single-year drops. And as far as India is concerned, so it was not just an absolute drop, but it's a drop relative to other countries as well. We moved downwards by 6 points. So relative to other nations, when we climbed down to 86 countries out of just 143 jurisdictions, that's a pretty low score. The second point, because it was mentioned again in terms of sanctity of contracts, enforceability of contracts, what is the position, as objectively as one can possibly assess? And here there was a mention made in the opening session as well with regard to enforceability of contracts in India, because that becomes a really basic measure as to how quick, soon, and efficiently do we as a system enforce contracts. That's the cornerstone if you want to have a $10 trillion economy and invite investors to come here with their funds. India ranked 163 out of 190 in the year 2020. And to give you an instance, it takes an average of 1,445 days and costs 31% of the claim value to enforce a contract through Indian courts. So you lose 30% in any case, and 1,000, almost 1,500 days. In contrast, the enforcement in Singapore takes 164 days and costs 25.8% of the claim value, while in the United Kingdom, it takes around 437 days as per the World Bank doing business, ease of doing business data. Now, what this essentially means is that as we learned in the morning, we're doing well as amongst the large economies of the world. We're growing at amongst the highest rates. But there is a huge and enormous scope for improvement. And this then should be our target. How are we going to improve on rule of law? How are we going to improve on enforceability of our contracts in a much shorter and swifter manner? And I think, speaking to some of the points which were raised a short while ago, the essential target has to be, or ought to be, to reduce legal risk. So what was mentioned earlier with regard to retrospective legislation, overturning precedents which have held the field in terms of investment from Mauritius, introducing press notes which suddenly change the ground rules before an investor has time to be consulted and has a time to react. All of this enhances legal risk, and investors abhor legal risk. So our effort and endeavor in the coming years and decades ought to be, and this is for your consideration, to reduce legal risk. The second point I wish to make is that we need a much more efficient commercial resolution of disputes mechanism and machinery. And here, as was mentioned by the President-elect, Mr. Chandiok certainly mentioned it and others did as well, we need our commercial court system simply is unable to deliver. So alternate dispute resolution is probably the only way forward, as I see it, in the near term for resolving commercial disputes, which means essentially strengthening mediation, strengthening institutional arbitration, and ensuring that courts adopt a hands-off approach, because if they can't deliver through the court system and people are forced and compelled to adopt ADR, then please do not interfere into resolutions which come out of mediation and which come out of arbitration. My next point is with regard to tribunalization. And this I place again for your consideration, because I think tribunalization of our justice delivery system has had enormous downsides. The public confidence which people have when they go to a high court judge, for example, is just not there under our tribunal system. I'm sorry to say it. But the example and instances we have of the functioning, and I gain this essentially from practitioners who go before the National Company Law Tribunal and the National Company Law Appellate Tribunal, though less so. But the NCLTs, just to give you one example in terms of tribunalization, to bring case resolution from a higher forum, the high courts, down to a tribunal, and then to find that the tribunals are not functioning on, the most basic parameters, including factors which we take for granted in our high courts, is a great disappointment. And if we are therefore to go up in these indexes, I think we need to really revisit as to whether or not we need to strengthen our courts and eventually give tribunals a backseat. The final points which I just wish to make is on leadership. I think leadership, of course, has to come, no doubt, from the judiciary, but there's a role for the bar as well. And this was mentioned in the earlier session with regard to the ravages which the international rule of law is facing. Perhaps there is a role for bar associations. Perhaps there's a role for the Bar Association of India in terms of rule of law. And perhaps at this particular moment in time in history, when we find that globally, across the world, political systems are just completely rejecting the international rule of law and committing crimes in real time, perhaps bar associations like the Bar Association of India can create a coalition globally and say that we as communities of lawyers must stand up for the rule of law internationally, because you cannot have a system of domestic rule of law if the international rule of law is in shambles. Trades, investment, etc. is all going across borders, and according, at least in my view, you must have a situation where there is a certain continuum and a general respect with regard to rule of law, both within our jurisdiction and without. This is not to suggest that there is a quick fix or a pill which you swallow and which you can sort of, solve every problem. There was another type of pill which was in the news, which some of you might have read about, where the government of India is pushing back in the Sabrimala case against public interest litigations. I suppose it's fairly convenient to have less accountability and less good governance if you do not have a court or a judicial oversight in that field. But on the subject of pills, let me again end with Piet Hein. Pills are useful against ills and against too many pills. Thank you very much.
Thank you, Shyam. I think he has reminded us of the irony of discussing rule of law in a global situation where rule-based order is thrown to winds and might is right is the rule which is being adopted. It's now open to all of you to join in the discussion and raise issues.
Suppose nowadays, if the government is consulting Adani and Ambani, so in this aspect, whether there will be allegation as a prime minister or government, the government is treating the side of the particular industry.
So, well, sorry, I didn't quite understand what you said, but I did remember, I forgot to say one last thing, and I would like to add that, which I was reminded by something which Mr. Vaidyanathan remarked on the side. I have to end on a very positive note. And the positive note is this, that post approximately 2012-13 till today, there has been a transformational change. The companies whose names I mentioned, I finally retired as chairman of Alstom, and I can tell you that one of the world's largest locomotive factories in the world, in partnership with the government of India, where government of India has allowed 74% ownership to a foreign company, has actually been built and is operating in Madhepura, Bihar. In Sanand in Gujarat stands one of the largest steam turbine and nuclear steam turbine manufacturing facility. In Maneja in Gujarat stands one of the largest hydroelectric plant manufacturing facilities. So something has definitely changed for the positive. The statement here following the President Mr. Prashant Kumar's invitation to the $10 trillion economy is the agenda. There I would just like to re-emphasize and say, I can tell you, government does consult. We do get invitations to come and have discussions with them and say, what is the problem you're facing? What are the things we can do? The issue I don't find there. At the very top leadership of all governments, because they have to be re-elected, they would love to see great investment come in their states and in the country of India. That's not the problem. And neither is the problem that foreign companies are unwilling to invest or they're running away, nothing of the sort. The problem is exactly where I pointed it from my perspective. I'll keep it limited to us. And that is in terms of the regulatory cholesterol that emanates from the interpretation of the rules and laws, rules which are written alongside the acts when they are passed, and the continuous fiddling that is done with it over a period of time. And what I mentioned, we like to see visibility in the sense that if I built something under a certain law, at least that law should remain in position long enough for me to recover my investment. That's about it. So it is not, I mean, and because it does not come in the public domain, let me tell you, there are a large number of very large foreign companies operating brilliantly here. An automobile company in Tamil Nadu, you need to follow that, Hyundai. They actually export almost all the South American needs of automobiles from Tamil Nadu. So all that is happening in the background.
I think time to time, I don't think Adani ji and Ambani ji have come up after 14, and I'm not exactly aware about their birth date. But I think Adani's and Ambani's were there prior to 2014 also. I would like to recall, as Mr. Sunen Sharma is well aware about the Vibrant Gujarat Summit, which took place, started in the year of 2005. Every 2 years it takes place in Gujarat. So, as per my own experience, being a part and parcel of MOU with other universities across the globe, then Chief Minister used to invite each and every industrialist, academia, Vice Chancellor to discuss, to suggest. Not even that, I would like to add, Prashant Kumarji. It was the wish of then Chief Minister to conduct the research project critically. If you are coming out with any kind of critical suggestion. That was the scenario in the Gujarat. And I am not criticizing him. I am just telling you objectively that multinationals I'm also not criticizing. We are welcoming multinationals. If you take the example of Kutch, you are very much aware, you were the part and parcel of many companies rather.
Could you be a little brief, please?
But let me conclude that an example like Vibrant Gujarat or large-scale consultation time to time taking place in this country. So I think our job, how we can frame such a network, how we can frame such kind of rule of law situation in our country. I do agree, I fully subscribe the views expressed by my senior learned friend Mr. Shyam and of course with Mr. Sunand Sharmaji. That should be the approach. Every time criticizing Adani and Ambani is, I don't think required.
Thank you. Could you, yeah.
If India wants to be a manufacturing hub and not just an assembly plant, it must move towards a legal system that values the survival of relationship over the education of failures. Yes. If India wants to be a manufacturing hub and not just an assembly plant, it must move towards a legal system that values the survival of relationship over the education of failures.
But it's still not very clear. What exactly the emphasis you are giving? What's the point exactly that you were trying to suggest?
At the moment, we are just manufacturing hub. We are...
Take the mic and you're close to your mouth.
At the moment, we are just a assembly plant, not manufacturing hub.
So your criticism is that...
Ganguly Sahab, can I reframe his question?
Yeah, please do this.
Yeah. See, what he's saying is that if India has to transform into a real manufacturing country or economy, you have to have a system of law which prevents disputes, which addresses disputes before they happen, and resolves disputes in an efficient manner.
We agree. You are right. Absolutely
Yes.
right. You are right there. If that is what the question is, the answer is yes.
Thank you. Now, just one thing which I want all the panel to address is, we have spoken about investment. But you know, when you talk about next trajectory of growth, it is going to be centered around innovation and technology transfer. Now, that is a most crucial part, how legal system has to address it. What are the risks which are there in terms of what hesitation, if you know a huge corporate wants to transfer technology to India, what happens to it, how it is protected, is going to play a major part. And then you know India's own innovation ecosystem and how things are protected. It is not merely an IPR question.
May I just make a comment on that? Let me just take an example. I was visiting a very major company in China, and as soon as I entered the reception area, on the wall were about 300 pictures, all of the patents that had been awarded to that company internationally. Similarly, when I enter in India, I rarely ever find that. In other words, intellectual property and its creation on the soil of India, owned by Indian companies, and the answer is very stark. I don't have to say it. Anybody in the room can research it via any method they like as to the total amount of investment made in India in R&D as compared to your competing nations. In India, it is abysmally small. Typically, in a large corporation in Europe or USA or Japan or Korea, the investment would be in the range of between 5 to 7% of the revenue, not of the profit, of the revenue. And not only that, it would be protected by suitable taxation laws to be written off as an expense and not to be charged as revenue, okay? So that is a huge gap, and that is still slow, but then that begs in a second question, which is a very large one, which everybody in this room knows. is education system reform. The very fact that we still have that higher rate of illiteracy in India, where it's a tiny country like Vietnam has achieved close to 100%. China has achieved close to 100%. We have to search within ourselves, and especially in high-tech education. How many PhDs do we produce per annum as compared to our neighbors, our northern neighbor, for example? These are the things one has to think about also.
Just to supplement what Mr. Sharma said, the question was, what Prashant has put it, that if you have to be a manufacturing hub, then you have to innovate. You have to allow inventions to come here. And then you put them into practice and you manufacture. There's one reason why we have been slow comparatively on that front is, for a long time, our patent laws was quite different. Until we became a party to the WTO agreements, we were doing what is called the process patent. And our business was flourishing, including the medicines, as you all know very well. Moment we shifted from process to the product patent, you need that R&D, a huge investment in R&D. We are in the process. There are many industries which have already come up to do that, but it's a slow process. It will take little time.
I think we have time for just one more question, and then we'll conclude the session.
Nobody is there, then, okay, we have.
Very good afternoon, sir. At the outset, I take this opportunity to introduce myself. I am Dr. P.V. Saravanaraja, advocate on record, practicing Supreme Court. If I look at this theme, it reiterates that to secure to all citizens economic justice. Now, my question to Senior Advocate Shyam Diwan, sir, is, sir, we are talking about the industries, we are talking about the government and legal reforms. Here, many of us are law students and advocates. As an individual also, we can contribute for economic growth. Now, as a lawyer or as a law student, what sort of qualities that we should possess, at least 2 or 3, if you narrate us, we can imbibe those qualities and we can also contribute to the growth of this nation. Thank you.
Thank you for that question. Well, I would say 3 or 4 points, both as young lawyers as well as law students. I think one of the great things which India has, both in terms of its immediate post-independence history, is enormous value for constitutionalism, which is built up over decades. And second, I would still regard us as a reasonably open society. But the way things operate, I mean, that's the nature of the beast. So governments will try, and it doesn't depend on, regardless of which political party is in power. Because they have their own agenda, they will try and limit and restrict spaces. So I think the most valuable thing which we have as a society today is that while we are high growth, which is a great thing, we've also been able to preserve the general contours of constitutionalism as well as a reasonably open society. I think we've got to fight for those spaces. I think we have to continuously remind ourselves that these are freedoms and spaces which many parts of the world citizens don't enjoy. So I think we need to value that, and I think we need to preserve and expand on those while keeping in view the great balancing act of ensuring that we attract investments, we have good and efficient business laws, and we are generally moved towards something which is more open, more fair, and more just as a society. I see a stupendous role for young lawyers and law students.
The President, Mr. Prashant Kumar, wanted to make some observations.
Yeah, just last one, because, what we are talking about is there is a joint venture and there is a foreign company which is coming up with technology. How safe that technology is in the hands of the joint venture partner. Once joint venture collapses, what happens to that? And with the slow pace of enforcement, of rights, including intellectual property rights, and now how it is looked at as a risk for the foreign companies who are coming to set up manufacturing bases, joint ventures here, and how that risk is to be minimized, reduced, handled is, I think, another aspect which the legal system must respond to. And on that I wanted.
If I may, sir. That is why I don't have the ready number, but I'm pretty confident that if you did research, in the absolute top end of technology, the foreign company likes to have a majority ownership. Where it gets into a minority ownership with technology, that is where the risk is seen. But if, as correctly the President has just said, that if that is mitigated, there can be a lot more flow in. And that is seen as a risk.
Thank you. Thank you all for the active participation.
Thank you, sir. I extend my sincere thanks to chair and speakers for conducting such a meaningful, fruitful working session. Thank you.
We are continuing with the next session. There is no tea break, please. इसके बाद कौन सा? इसके बाद हम टी ब्रेक करते हैं. हाँ, तो अभी there is no tea break अभी.
Yeah, absolutely fine. We must wait. Thank you.
We will have the tea break after a short 1 hour session, because then, you know, we have to spend time between dinner and the end of the working session. So I think it will be much more creative to have tea and move around rather than have tea now and then wait without anything in between. So please stay back, and it's hardly 1 hour we have spent after the lunch. So please stay back. We will start the next session. Only the changeover is taking place.
Hello, good evening, everybody. Please be seated. Soon we are going to start our next session. There is slight change for today's session. Mr. Justice Subramaniam Prasad couldn't make today because of bereavement in his family. So our President, Prashant Kumarji, exceeded our request to chair this session. Please welcome Mr. Prashantji. The other speaker is Mr. Vibhu Prakash Tripathi, Senior Advocate, Odisha High Court. Please come on the stage. The another speaker, Mr. Harish B. Narsappa, Senior Advocate, Karnataka High Court. Please come on the stage, sir. We have industry expert, Mr. Sanmit Ahuja, MD and CEO, Bharat Technology and Impact Accelerator and Director. Please come on this stage. We have Mr. Amarjit Singh Bedi, our Honorary Secretary. Please come on. We have Ms. Sarda Naganan, Advocate. Please come on this stage. And we have Session Rapporteur, Ms. Kim. Please come on the stage. Sir, thank you very much. I welcome all of you on behalf of Bar Association of India for this wonderful session. Over to you, Prashantji.
Thank you very much, Rawatji. Sometimes, there is too much of anything is bad, but, I had to step in at the last moment. Also to see that, the timelines which were not being kept earlier, thanks to Vaidyanathanji and all our wonderful panelists, we have covered that, and we are starting this session dot on time. So we have, because, economy is not merely about GDP growth, it is also about covering the deficit. So we have covered that deficit. So we are very much aligned with the theme of the convention itself. Friends, when we talk about artificial intelligence, when we talk about the technology, the digital technologies, we also talk about something which we hardly recognized had an economic or any other value earlier, that is called data. So all these three aspects of digital technology, artificial intelligence, and the role data can play in improving access to justice, efficiency of justice delivery system, helping it become more predictive and evidence-based, including the internal reforms in justice administration system have to be evidence-based, or what is called the data-based. And as members of the bar and bench, what we grapple with, a very critical issue of appointments to the bench. Now, in large number, large measure, even that has some connection with the data which is emerging, which is available, which can be utilized to select better candidates. The claims can be verified. The specializations can be mapped. And the performance can be assessed on empirical evidence basis. So there is a huge potential of movement from subjective ways of governance to objective ways of governance. There is a huge jump from how an interface in a court and arbitration takes place because of the digital technology, because it came as an imposition and adaptation forced by COVID pandemic, but then its real time utility was recognized and it became an almost standard operating procedure. So we have assembled a panel where we have one of the star, and it is very instructive to have voices from the jurisdictions which are much more challenging, but at the same time, because of the right leadership, could be pioneers. So we have Vibhu Tripathi from Odisha. You will not ordinarily think that Odisha will be a high court, which can be in the front line of these endeavors. Then we have senior advocate Mr. Harish, who was part of the mission and the committee created in Supreme Court on the e-court mission. He was involved with that. And from industry, we have Sanmit Ahuja, who has been working. I know him from almost 2006, and we have been working, and his forte is technology transfer and how all the things get their meaning in a technology-driven environment, be it economy, be it governance, be it implementation and execution. So how seamlessly today technology interfaces and what challenges it poses, what deficits which are there, and where are the deficits to be filled. So Sanmit, at least from 2006 itself, I have been working with him, so it's 2 decades of that experience with India. Then Amarjit is not here in his capacity as General Secretary only. Amarjit was the domain consultant on IT for the Asian Development Project, Bank project for New Delhi, for Delhi Judiciary. So he worked with the ADB team as domestic consultant and domain expert. So he dealt with this issue way back when most of the people even did not understand what the concept of e-court is, how case management systems work, how they are going to streamline the adjudication process. And then we have a young lawyer from Bangalore, Sharda. Bangaloreans have a natural affinity to all things technology. So here she is, and she has done a research paper on that. She has written a paper. So we have a very good panel. I will not hog any more time. I will first ask Bibu, who, as I said, that how challenge can become opportunity.
the chairperson of the session, Bar Association of India's president, Mr. Prashant Kumar, the speakers of the session, my dear Dr. Harish, Mr. Sumit Ahuja, my dear General Secretary of the Bar Association of India, Amarjit Singh, the young lawyer, Nagananda Madam, distinguished lawyers from all across India, office bearers of the Bar Association of India, and my dear students. I do not know what prompted my dear Prashant Kumar to call me a couple of days back to ask me to deliver a talk on this occasion. I must share with all of you, after my exit from the National Law School, Bangalore, way back in the year 2000, I was all the time thinking that I must do some work on this e-commerce and cyberspace, also on AI and digital justice. And whenever time was permitting me, I used to do that work. And right now also, I'm doing research on these areas. But I never shared this fact with my dear Prashant, so I feel humbled and I owe a deep sense of gratitude for him for inviting me to this conference. Friends, long back, because my young friends are all there, who are students of law, a very renowned thinkers of our time, Richard Susskind, he had written 4 books which inspired me to do work on this area. He has written this book on the impact of technology. For the next couple of years, what will be the impact of the technology? And the books are The Future of Law, The End of Lawyers, Tomorrow's Lawyering, and The Future of Profession. These 4 books. And his task was to impress upon us the re-engineering the entire legal process, how it will take place. Because many of you have heard the earlier session speaker, those who spoke about fairness, predictability, certainty, and accountability, which are the facets of the rule of law. Now the question is, how the artificial intelligence system will be able to keep track of these basic non-negotiable facets of the rule of law. Friends, a couple of days back, some lawyers brought me a brief. And I had a look at it and I said, how did you file the civil suit? I think it must be AI generated civil suit. He said, yes, sir. I said, have you checked up these laws? He said, no, sir, I have not checked up the laws, but I found out that this is the way the ChatGPT prepares these civil suits. Why I am saying is, first let me explain to you, because I have structured my presentation. Within another 7 to 8 minutes, I must finish it up because I know my limit. The timing is very important. First is the flaws in the AI legal drafting, because many of us are making use of it. So therefore, the flaws, let me first explain. First one is you look at it, is hallucination. What do you mean by that? Because it sometimes confidently will come up with few facts, but these will be false facts, false case laws. All of you have remembered that Supreme Court, which took cognizance of that Mercy case, and they issued notice. So hallucination is something which will be there. AI does not truly know things. It guesses best patterns. So that's the first thing. So you can tell a judge about a case which never existed. That's what is happening today. Then comes bias amplification. That's very important for all of us to know. Because AI only learns the old human biases, whatever is there. The data, which we call it data as infrastructure. So the old human biases from past judgment, that will be there, and that will make the system more worse. Take for example, if past court decisions were not fair for the poor people, rural people, marginalized sections, or disempowered sections of the society, then that will not come while you are doing the research in the AI itself. Third factor is precision over recall. AI is good at finding what it is sure about, but it often misses the important points. If you give AI for doing your contract vetting, sometimes you will also find that important points are missing. Then you find verbosity without substance also. You find that AI writes long, beautiful things, but substance is not there. Now, there is also a context blindness. What does it mean? AI cannot understand the real life situations. Please understand. It cannot understand your emotions, or it cannot understand the unusual fact. A witness comes to the court, witness cries. On what question the witness cries, that fact will never come in the AI, because many of you are making use of the AI for the purposes. So the context blindness is very, very important for us to understand. Then how do you make responsible use standards? AI is okay for helping out with simple tasks. Please don't use it for making a final decision. Now, Indian context, let us look at it, because that's very important. India has too many pending cases, as we discussed in this morning. And important decision is access. Yes, people may have access because of the AI system, because today morning we discussed about the court committee coming up with a WhatsApp with regard to notice to be served. There may be many more such apps will come up. The question is, AI will make it more cheaper, no doubt about it. It will make it more easier, no doubt about it. But then we need to look at the quality. That quality has to be taken care of. Then the other factor which I was also looking at is the judicial dependency and the basic structure. As many of you know that in India, we have this popular thing that justice not only be done, but it must be seen to have been done. So therefore, public visibility has to be there that justice is being done. That has to be also taken into consideration. Now, the next point which I wanted to make is AI-influenced outcomes are less legitimate. Even if AI gives the same answer as a human, you think, but people trust it less because it feels less fair and human. The principles of natural justice is also in the digital age, has also to be taken care of, and that factor, both audio ultrapatum and also the no one can be judged in their own case, has to be taken into consideration when the digital justice points are to be taken into consideration. Then the online dispute resolution mechanism, there's a paradigm shift now. All of us know about it, that because ODR is like ADR 2.0. So we need to understand that despite of the ODR, which has a huge potential for India, but we also face problems what Prashant was telling to me that there are many places in a place like Odisha where the internet connection is very, very poor. Now, let us look at how other countries have looked into it. Now, you have got a new law in Europe, the European Union Artificial Intelligence Act 2024, which talks about a pyramid of the minimal risk artificial intelligence. It explains that what are the binding rules in case of the AI. In India, maybe we need such a kind of a binding rule because till date, we do not have any binding rules. Now look at what are the other countries, how different legal systems have approached AI in courts. You have Estonia, where the AI small claim judge in Singapore, they handles dispute under 7,000 euros with human appeals available. That's the first model. Digital Signature Act 2000 preceded X-Road, demonstrate that legal infrastructure must precede digital infrastructure. Estonia is the country which they build the law first and thereafter the technology which will protect the fundamental right. Then you find the compass recidivism, where a lot of criticism is there with regard to the sentencing pattern of this, because you just cannot take into consideration of the past criminal antecedent of the people, or you cannot predict what will be the future criminal activities of that particular accused persons. Now, do you require a horizontal reservations, horizontal AI, or do you require a vertical AI? That's also a question for all of us to think. And in Indian context, you have a Niti Aayog which sets certain advisory principle, but it has no legal force. So we need to have a law in this regard. And my last slide is, what is the way forward? The path forward is, we need to enact a judicial AI act, or wherein a statutory framework governing AI use in courts. We need to have the preservation of the natural justice principle. We must have a two-layered regulatory architecture. We must build our legal infrastructure first before the digital infrastructure, and we must invest in AI literacy and multilingual access. Friends, since I have prepared so many slides, I thought I must wind up by saying that you require big data. Without big data, you'll be deaf, you'll be blind in the digital justice system. Thank you all.
Thank you, Vibhu. You have laid out the contours. But since our whole theme has been about investment, protection of investment, and we are looking at it, so just to loop that thinking in. See, investment to innovation to marketing for recovery of investment. So one way one can look that artificial intelligence, the term itself is a very big marketing tool. And unless until we demystify it, that what it means actually. Artificial intelligence is two things. One thing that is large language models, in which these models collect data from all the data domains, and through increase in the computation speed and capacity, they are able to analyze that data and create inferences in real time. So that is the large language model. Then again, the question of bias comes because it's a large data set. And the data set is from the resources where data gets generated. So bias is built in. But then there is another aspect, because when you come to analysis, the second tier kicks in, that is agents. Now the agents which work, what you call ChatGPT system, which work on the basis of large language models and create these outputs. Those agents have a heuristic and an analytical tool. So that heuristic remains within the data sets, but that heuristic also trains the system that you have to highlight anomalies, you have to highlight contradictions, and then you have to come. So the minority voice, if we say in legal term, also gets highlighted, because that is how the system is designed. So two takeaways here. One, as lawyers, when we use, do you straight away go to the court with your fresh junior coming and giving you 3 case citations and start arguing on that basis? No. So same way, an AI tool is going to throw some output. You have a responsibility to look at it. You have to use it, groom it, train it, ask questions, put the AI system to work the same way you put your chamber junior to work. That's how to go about. If you don't do that job, you are going to fail in your practice. So it is how to use the tools, and there are some guidelines which Mr. Thakkar is there. Bombay Bar has been the first bar to put out guidelines on the use of AI. The second aspect is that if you are challenging the AI, if you are feeding it with ideas which are not the dominant discourse in that field, the AI picks that up. So if you have to fight the battle, AI can be your biggest amplifier. So how to strategically use, how to hone your AI skills is something which one must realize. It has potentials both ways, to develop and to destroy. So now I will ask Sanmit, I will follow the lead of Vaidyanathanji, that one legal, one industry, and then carry on.
Thank you, Prashant, and the Bar Association of India for having me here. When Prashant, you asked me to put my thoughts together, I thought I'll sort of step aside and play my character and nature in real life, and not try and just talk about data in the context of judiciary and legal framework, but in the context of how policy, technology, finance, and legal frameworks intersect. So and this is the first, as practitioners on the field, if you ask people, I want to go from point A to B, you get that answer as illustrated on the screen. And the same is going on with all the AI tools, right? And that's why this is happening, is because of those semi-real, some synthetic data sets. So it's not just biases, it's also the hallucinations that Vibhu mentioned. And it's the data sets are starting to get more and more synthetic, right? So to the young lawyers in the room, yes, do rely on these new advancements in technologies, but do take time to read. Why? Because the person on the other side who's arguing the case, the opposite to you, is also using the same systems and might be slightly better prepared than you are. So as practitioners, and I'll to talk about who we are, what we do in a minute, but if we have to build a 10 trillion Bharat, 10 trillion India, these are the 8 building blocks that we have to utilize in every sphere, every domain. Whether it's education, whether it's water, whether it's energy, whether it's transport, whether it's farming, every system has to develop its own building blocks. And if we don't, we're not going to get there, period. I'll give you a couple of examples. If you go to NGT, we work a lot in the environment sector. In the NGT, there's the National Green Tribunal. There is a case being heard on a particular river in the system, in the country, and the prosecution saying, no, the river is polluted, and the defendant saying, no, the river is clean. Right? And both are giving very detailed reports from top engineering consultancies, right? And those reports are saying absolutely opposite of what the system really is. Right? So our question really is there a single source of truth? Right? And if there isn't a single source of truth, how can you deliver a governance system, a judicial system that would uphold the laws of the land and protect the investments that's coming in? And that's what, Prashant, you mentioned right in the morning. The delays in the systems, the deviations in the systems, they become tactics for those who have the clout, who have the power, who have the muscle to beat those who don't, right? So there has to be a single source of truth in every aspect, in every sphere. The top-down approach will not work, right? And Vibhu, I slightly differ from you. Build the legal framework before you build the data architecture. If those who are the domain experts don't build the data architecture, right, you will not know what legal framework to build, right? So it has to be iterative policy making. You can't get to the absolute best policy on day one. So build your data systems from bottom up is our approach. And I'll give you 2 or 3 examples. So this is a project, this is a satellite image of Varanasi during monsoon season. The National Disaster Management Agency, the insurance companies, UP state government, National Ganga River Basin Authority, everyone wants to know what is happening in the river system, what's likely to happen in the river system when it's flooding. Right? Now, we don't have data, so insurance companies need to know data to what property to insure, how to insure it, and they have to go in the past, and we don't have that data. Right? So we partnered with the European Space Agency, and this is not optical camera, so when it's flooding, it's raining. When it's raining, it's usually cloudy. And optical cameras cannot see through cloud cover, so you need special radar satellites. So we partnered with the European Space Agency to develop this data architecture for Indian river systems. So satellites can see through the cloud cover, and we've gone back 20 or 30 years in time to establish a baseline. So if you don't have a data baseline, also you can't build your governance structures and your management structure. So that's example number 1 on how data is being used in real life situation. Not only we're doing this for Indian river systems, we've now, again, using the 10 trillion analogy, how you're going to get there unless we start, 6 out of 8 billion people live in the emerging markets. India is the largest living lab, right? The conditions that we offer for technologies to prosper and technologies to get harnessed, no other country has that. But we have to use that as our weapon, and if we don't, we're going to miss the trick and we're going to miss the boat. So not only are we doing this for Indian river systems, we've now signed up 30 countries who are going to get their river flood analysis from us, and this is a 30,000 square feet command center we built in IIT Kanpur. Another example of building your data sets from the bottom. So now that we've established that methodology on river systems, we said, let's see if we can apply it to healthcare. Right? And very specifically, healthcare, India is a diabetes capital of the world. For those of you who don't know, there's a specific condition of diabetic foot, which has foot ulcer. There's 1.5 to 2 lakhs amputations per annum that happen. And we can prevent those. We can prevent those if we have the data. Now that data exists, and the data is so fragmented that you cannot, those who have the capability and capacity don't have access to the data. Those who have the data don't have the capability or capacity, right? So again, to build those, so if I go to Ministry of Health, they have the capability and capacity, but the data is super fragmented in states. How do I get the data to one single point? And so just using the river systems analogy, we said, okay, let's do the diabetes analogy. And now you start seeing the trend that data has to be very, very specific, very, very granular, open source, interoperable. Please don't create multiple sources of truth. If we create multiple sources of truth, we will falter, right? So that's another example. So our goal is amputation mukt Bharat over there. Prashant, you mentioned how do you bring investments, how do you protect investments? So this is a life cycle, this is a 20-year life cycle, which I've shown you. When a technology enters the market, it gets validated, the government or whoever the client is wants to do due diligence, then you'll put the first commercial demonstration project, then you'll multiply, and then you'll scale it up. This happens over 20 years, right? And with every stage, the actors, the investors, the stakeholders are changing, right? So again, if we create multiple data sets on the same technology, imagine a person who bought into the technology 10 years ago, 15 years ago, a lot of those people have retired, a lot of those people have moved on, right? So that knowledge has dissipated. So what starts to happen, hallucination starts to happen in real term, not in AI's context, but people start making assumptions and putting opinions on that very, very technology. So again, what we've now started to standardize is build a common data set, and for every technology, we're building the largest technology evaluation data set in the world, which will accelerate this. So that's our approach. Largely, we sit, I'll tell you what we actually do. So Bharatiya was spun out of IIT Kanpur, 15 years working in the Clean Ganga mission. And what we realized, we were sitting at the intersection of policy, technology, and finance, and a lot of those traffic and knowledge was falling between the cracks. So we had to bring everything together, and the manifestation of that is Bharat Technology and Impact Accelerator. And our approach really is have your principal components, but have data as a permanent building block in everything you do to build Viksit Bharat and Samarth Bharat. So that's our vision. Thank you very much.
Thank you, Sanmit. And what we are looking at is that data is the infrastructure for good governance, and data can be an infrastructure for dispute resolution as well. Because more empirical evidence, especially on economic issues, more wholesome the outcome. So that's why, when we are looking at a $10 trillion trajectory of Indian economy, all these things must blend in our practice and in our institutions seamlessly. It appears to be a disparate strand, but these are very, very interconnecting nodes without which we can't move forward. I'll just add one more thing. From morning we are comparing with China. And what another very huge distinct advantage China has, which we also have, but they have put it to use. China, innovation, internal market. Till last year, they were the largest populous country. So what happened? The technology investment could be justified because of the upscaling available within the domestic market. That's how China leapfrogged everybody to become leader in electric vehicle market, EV market, and several other areas. So how India has to have investment of innovation, have legal protection of innovation, and how to create the fertile ground for Indian internal market to help it upscale. And we are a rule of law based country. So world over, people will trust more, even in terms of climate change, because it is not just hundreds of $trillions required for climate change. The requirement is an upscale technology which is of lower cost. And India has a right ecosystem, provided we set our basics right. So $10 trillion can just be a beginning. If we do these things right, doubling that is not far away either. Now, I will request Mr. Dr. Harish ji to share his experience, how the systems have been built and what they ought to be.
Thank you, Prashant. Dignitaries on and off the stage. I think I'll actually start from where the previous two speakers stopped. I feel that we are facing a unique opportunity to address the 2 or 3 critical problems that our legal system, particularly the judicial system, faces. From morning you've heard about the pendency, the processes, the rule of law challenges, and how the dispute resolution system is actually the center of the rule of law challenge that we face. All lawyers in the room will know, if you go before a judge on any day, you see he has a list of about 80 to 100 cases. You know it's humanly impossible to go through those 80 to 100 cases, right? So if 80 cases are listed, 60 of them will get adjourned. There's no other choice. And what is likely to happen on the next date that case gets listed, also we don't know, because it's unpredictable. So that's where a couple of us started studying this problem about 10 years ago as to why is this, today it's a 5 crore number, at that time it was still 3 crore cases delay. So what is the root cause of it? And then technology was being used by the judiciary, so how can we use technology to address some of these problems? And today, mere usage of computers and software has now, we have now faced with AI. And lawyers, we are worried or excited about, the substantive part of AI, how to summarize cases, case research, drafting, and the problems that come with it, the worry that whether that will replace lawyers, etc. But I will talk about a different opportunity for the Indian judicial system. I'm not going to talk about, Harvey or Lucio or, Jurisphere, all the various tools that are already many lawyers use and many lawyers are wanting to use. What we've been talking about since morning is the rule of law. I think many people have spoken about the 4 or 5 points, so I won't repeat that. But look at the box at the bottom. Right? The direct cost, and this is a study that Daksh did a few years ago, the direct cost of pending disputes in our country on a conservative basis is about 2% of the GDP. And in tribunals, and in the earlier session, somebody spoke about tribunals, the economic value stuck in tribunals, the top 10 commercial tribunals, is about 7.5% of the GDP. So that's the problem that we are facing about. And why is this an opportunity? Because I'm not so concerned about, digital justice, whether AI will replace lawyers and judges. I think we can all be reassured that that's a long way away. May not happen in, during our lifetime at least. Yes, there are some, and people quote this example to scare everybody else. In jurisdictions where there's a dispute of, say, $150, why will anybody spend time on lawyers and courts? So there are systems, ODR systems, as to how that $150 claim can be sorted out. Like in our country, if you have a 1,000 rupee problem or a 500 rupee problem with Swiggy or Zomato, will you go to the consumer forum? No. So there's some, tools that are being developed to sort that kind of those kind of values, disputes involving those kind of amounts. But if you look at the judiciary and the tribunals, we have a chance to leapfrog from paper to AI tools without having to struggle through the various steps of digitizing each level of the process that we follow. And all of us lawyers know that we are a heavily paper-dependent judicial system. Even when there is e-filing, and those of us who practice in the NCLT, we see this, curious anomaly, which I don't know whether it exists anywhere else. Oh, I have filed e-copy, I need permission to file physical copy. It's meaningless. So how do we get over this? And what are the pain points? So, I set out where we can use AI tools. Certainty in listing and, certainty in the event of every case. Then improve consistency, procedural fairness, predictability that people have spoken about. But maximize judicial time available for substantive duties. And we did a pilot project here in Delhi with the, in the Delhi district courts. The challenge is not whether judicial time required to decide any dispute increases over years. The challenge is to find judicial time in a short period of time. Meaning, if a case is decided in about a year, and these are actual numbers, I'm quoting a few anecdotes. So if in a murder trial, if a murder trial is decided in 1 year, the amount of judicial time spent is about 34 to 36 hours. And I'm not talking about the time a judge may be thinking about, how much sentence or how should I deal with the evidence, but actual time spent in court that is recorded for evidence, for arguments, etc., about 34 to 36 hours. Now, if the same case takes 10 years or 7 years, which is the average in most parts of the country, then the amount of judicial time spent increases only by about 15 to 20 hours. So 34 hours goes to about 50 hours or 54 hours. So that is a challenge that we are facing, how to find this 34 hours or 50 hours within a 6-month period, which should ideally be the time, when the judge is also fresh, he hears all the evidence, and he decides. So how do we maximize judicial time? Why should a judge spend 2 hours in a day adjourning matters and fixing another date? Or questioning whether a print of a digital photograph is an original or not, right? And we are talking about AI. On the other hand, you have office objections saying original photograph not produced, right? So how do we use AI to address some of these issues? I think that's the opportunity we have, and that's why, the Sanmit talked about domain knowledge, and this should come from lawyers and judges. We need to address this problem. We can't expect a technology expert to solve this problem, because he will solve, because the majority of the investment into legal AI tech is happening in different parts of the world who don't particularly care about our problems. Now, support innovation of judicial operations in line with emerging global standards. See, there's one court now in Kerala which has started functioning. It's about a year now, more than a year now, where for 138 cases, section 138 of the negotiable instrument cases, there is more use of technology. It's a completely online court. So it's an experiment that different courts different high courts, different states can try in different areas, because different states and different high courts face different problems. Now, this is a very, very busy slide, but this is something that we have been working on. So we created this slide along with a technology consultant, and basically identified all the process, procedural process, substantive process, and the case management angle essentially the life cycle of a case in a judicial system. So how do we use AI to make sure all this goes through smoothly? I think that's the challenge. And this, fortunately for people who want to look at this, nobody else is working on it. Unfortunately, nobody is working on it. Right? So, and the biggest stakeholder in this, to solve this, are the lawyers, legal community, including lawyers and judges. And we need to take the lead to figure out what to do. And what do we need? What data, when Prashant talked about data, and the use of proper data, to solve the Indian legal system's procedural problems, we can't use large language models from other parts of the world. It has to be data from our own courts. And our courts, we generate a lot of data every day. I mean, just imagine, I think even in the previous session, the number of cases before each judge was mentioned. There are about 23,000 courts in the country. On an average, there are about 100 cases listed. Just imagine the amount of data we are generating just every day. That is what we need to build a system that will help us. The challenges are, we are still on paper. Even when e-courts phase 1 started and until e-courts phase 3, and one of the objectives of e-courts phase 3 was how do we make our courts digitally native. That is, it should not become a reporting mechanism. Technology today, until and unless, until COVID forced us to adopt, video conferencing, it was not being done. It's not as if the technology was not available, but it was not being done. So e-court started as a reporting mechanism. So people still maintained paper data, and then one clerk entered that data into the computer. So even if there's a mistake made in entering the data, or if there's a mistake made in capturing the data, that data was wrong. Then some of us figured out that you don't need to do that manual process. For example, we came up with the idea that if you scrape cause lists of all the high courts every day, then you can, and do it for about 6 months, you can get a clear idea of how many cases are pending in the high courts. So similarly, and that prompted even the e-courts committee to build the entire NJDG architecture and the reporting system that you see in NJDG. But moving from a reporting mechanism to a functioning mechanism that allows you to leverage the power of technology to make your life more simple. I think that's the opportunity that we have with AI. Now, how do we get over some of these data problems? I think because AI is developing so fast, some of these paper-related problems may not be difficult if we adopt certain basic standards. And that now different courts have started using it. There are many high courts, many district courts are using different tools, AI tools. But it's all individual driven. There's no judicial AI policy. There's a discussion happening. I think I saw in the last 10 days, 2 high courts have come up with AI policy, Gujarat and another high court, and said you can't use AI for certain things, but you can use AI for other things. But I feel that there's a lack of a clear guideline and a clear vision of what AI can do for us. And for example, which tool do you decide to use in the High Court? Currently, the most popular tools being used are transcription tools. Is that really what is what is blocking the progress of the case in our courts? There's no study. So we recently did a study with the UNDP, and the paper was released in Delhi about 10 days ago, about how should AI be used, and Bibu covered this in his presentation also, that you need to make sure that there is no bias, you need to make sure that there is sensitivity, you need to make sure that there is clarity both to the judges and to the lawyers and litigants about what is being used. Today, if an AI tool is being used in the courts, does everybody know about it? If lawyers are using AI, does everybody know about it? We don't know about it. So the opportunity to build tool for the judiciary exists, but a policy about what we want to do. A policy need not be, need not sort of envisage everything that's going to happen, but at least identify the 5 big problems that we are facing to solve this rule of law problem that the judiciary is stuck in, with a view to, the theme of this conference about, trillion-dollar economies. Unless we identify the 5 or 6 problems that we want to solve urgently, and then say, let's solve this by creating an owner for the system. Currently, what is the challenge with judicial process reform? And that is the same problem we will face in adoption of AI, is nobody owns the problem. Unfortunately, the term of every chief is very, very small. And by the time they understand the problem, it's time to retire and somebody else comes along. So we need to create an ownership with the bar and the bench. Maybe that's where the Bar Association of India can take a lead and convene a meeting of at least the top 5 or 6 high courts where this need is there, along with leaders of the bar and leaders of the bench, and say this is the process we follow. I mean, there need not be a uniform process. Everybody should be allowed to experiment, but there should be clarity on what we are experimenting with, and there should be clarity on what we want to achieve. And as Sanmit said, this is an opportunity that arises once in a lifetime, and we need to adopt it, meet this challenge, and leapfrog the various problems that are causing, the various problems related to rule of law that are an obstacle to the trillion-dollar economy. So thank you.
Thank you, Harish ji. One part of your introduction is about Daksh also, which has done tremendous work on judicial policy and what improvements can be done. Here, I'll just narrate, I'll deviate a little. We are talking about dialogue with the bar and bench, institutional dialogues. When we were in Brazil, Nitin Thakkarji, head of Bombay Bar, narrated how difficult it was for him to get the building plans of the new building. They were not shared with the bar, despite repeated promises, and we are talking about AI infusion. So what is happening is, when judges do policy making, and the leadership has short tenure, and they have full docket to discharge, they don't have time. So policy making is just not happening with a sustained, focused attention by those who make it. So getting others on board, so what happens, it is just like a Maggi noodle, a ready recipe comes, and you say, we don't have time for preparing a breakfast, let's have 2-minute noodles. So judicial policy making has become a 2-minute noodle thing, no stakeholder consultation, nothing. And that is where we have to have a fundamental change. I think 15 years back, I presented a paper to that time Chief Justice, how we have to turn these judges-driven temporary committees into continuous policy-making bodies in those sectors, how to create a judicial policy and planning center at the same scale as national judicial academies. But something Mickey Mouse was created instead of that, and we have this system of ad hoc governance through very short tenure, part-time judges. Part-time means for this activity part-time. Judges doing the policy making. So Supreme Court finds deficiencies and addresses governance deficit in every other institution without addressing its own. It has the weakest internal governance system in place. So that is the big deficit to be addressed. Now, before we will go to Amarjeet last, because I told you he actually worked on the Delhi Judiciary project, and another thought which Harish ji shared is that you have to have domain experts. So Barry Walsh was heading the Asian Development Bank team. He was the project head. And he got in touch with me that we need to do this in India, but we can't do it. He was an Australian, then there were some, Britishers, others and all. They said, we don't know about, we have the funding, we have the project, but how to do it? So then I put together 5 domestic consultants for them in HR, in IT, and Amarjeet was very dear from the beginning with me, and for him the biggest incentive was that his per day ADB allowance was $200, which was equivalent to what he was getting as a junior for a month. So he did it with passion and drive. So now I will ask Sharda to present her ideas.
Good evening. So my ideas are approaching this from a slightly different angle. So the issue of the rule of law is about access to justice by citizens and by the populace. So economic progress in a country is driven by citizens or organizations and institutions comprising the receivers of justice, so to speak. Therefore, to approach reform slowly from within a system as a solution that we must find within it alone, I believe is insufficient to ensure the completion of the circle or the delivery of justice to the populace. I think that it's necessary to approach it from a different angle. So the fundamental bedrock of what is missing, which is what we're seeking a solution from in the form of judicial reforms, is actually trust. So there is a trust deficit in the judicial system, and this is primarily caused by delays, by the fact that people don't believe that the system will come through for them. So it's perceived to fail in the eyes of the common man because people don't see that the law and the judiciary is a structure that exists to empower and to protect them. The reason for this is that the perception is that the stakeholders of justice are simply the judiciary and all its officers. Somehow people appear to have absolved themselves of participating in the system as stakeholders of justice. So it's an external system that exists, but the common man is not a part of it. It seems that it's a structure that exists in a lacuna, like an external entity that must come to the aid of a common man when it's needed, but he has no role to play in participating it and in fortifying it. It should be a system that exists for his protection, that empowers him, and that he must participate in order for us to actually make it strong and efficient. So its ability to render justice, can be streamlined by integrating artificial intelligence processes to bolster the structures that do exist. But I do believe that it also is necessary to approach it from within the, from an outside-in approach, from the perspective of citizens and litigants that actually require the justice that it delivers. So from within the judiciary, as was discussed earlier, I think the issue stemming from AI usage is that there's too much data to sift through to retrieve the accurate solution. Funnily, from the opposite approach, from the citizen's perspective, there's too little data that the citizen has on what the law is and how it exists to empower him. So the citizens generally have no awareness of the law. Most people are simply unaware of the rules and procedures that exist when conflicts arise. Like let's say that a person is driving on a street and he gets stopped by a traffic policeman. He's given a ticket. Now there is no information about what procedures must be followed by a policeman in giving him his ticket. There is simply no awareness, and there is no easy way to retrieve this data. So there's because of this lack of awareness of the law, people are simply uneducated and unable to protect themselves because of a lack of legal education. So they're unaware of simple rules and regulations, and they just they're taken advantage of, they're preyed upon, and their ignorance leads to significant shortcomings down the line, and it causes blockades in the entire system. So AI as a game changer can actually be brought in here in order to bolster citizens' participation in the entire in the system, so that citizens are actually exposed to the law. So I believe the need of the hour is actually a law GPT. So this is something that will help not only citizens but also corporates. As stated by Mr. Sunand Sharma earlier, people have no awareness of what is going to change tomorrow. So there is a law that's laid down, then there is an amendment, and there is no compilation of information in one place that's easily accessible, by which people can simply log into a system and say, this is my problem, I was stopped on a road by a policeman, I was issued a ticket, the policeman gave me a challan, or didn't give me a challan, and I paid X amount and I drove off. Now, when this occurs, a citizen has simply no awareness of what are the procedures to be followed. Many times the amendments that take place, the information that is available in some obscure official gazette that is just not available, it's not accessible. And people don't even know what is there to protect them or empower them at a particular time. They just don't even have awareness of where to look. So it's necessary for the state to create a system whereby citizens may participate in a structure and make it something that can fundamentally work efficiently. It's also necessary, so for example, I believe that a person should be able to go online, and it should be something that's hosted on a state platform. So like just the way that we go online and pay our traffic challans or pay our property tax, there should be a structure, an AI system that's supported on a state platform by which a person can go there and just like an FAQ ask, this is what happened, what should I do? And it should actually bring out and list out all the rules, laws and procedures that govern that particular instance, every single one of them. And it should also proliferate information about judicial precedent that is set on the subject matter in order to make a citizen aware of, this is a similar situation that occurred with me, this is what the law has laid down, what should I do next? So that when they go to a lawyer, they are not given ineffective counsel. Many times the issues that stem from, from like too many cases in the system, etc. What happens is that many times lawyers' counsel is ineffective. And people don't know what good counsel is. Many times lawyers fail to state in a plaint what they must state. And at that initial stage, when you fail to do that, it has lasting repercussions that are irreversible, due to which a litigant can never ever seek recourse later. So these are irreversible issues that are caused simply due to gaps in information processing and awareness and lack of education. So I believe that if there is a system that informs a citizen, it's easy for a person to access information, which is the fundamental bedrock to actually fixing this going forward. So I believe that gaps that exist due to lawyers' incompetencies at the very least can be overturned because a citizen is educated. People who receive an accurate legal advice, they simply don't know better. So prevention as a reform comes in here, because when a person knows that, okay, this is not the right advice that I'm being given, or this is another option that I can take, then it prevents, issues from arising, obstacles from arising later, and challenges that can occur because of frivolous litigation. So many times, like strategy, this is something that lawyers should be able to do but fail to do. So basically going in with the right approach. Sometimes defense is not always the right strategy. In many of the cases, recently I handled a case of, of a domestic dispute where there were all sorts of frivolous cases that were filed against a husband against a wife of domestic violence, all kinds of things. And here he was, defending and defending. Whereas there was another approach, because all of the evidence that had been filed was fabricated. And I think out of fear of repercussions or just fear of participating in the system, there was no thought that was applied to how else could I approach this so I can actually remove all of these cases from the system. So we managed to actually have at least over 15 cases withdrawn from the legal system simply from approaching it from another angle. I think this would actually reignite faith that people will have in the system. And, a participant, a party that is armed with information, it can preempt future conflicts. He knows what the right advice should be. He knows what he's seeking. And you put him in the position where he is responsible for the future outcome, at least by arming himself with information. So when he goes to council, he's not simply completely dumbfounded at, and has no opinion on what is being, offered to him as advice. So I think participation of litigation as a stakeholder would restore faith that people have in the system, and it would allow for a more efficient functioning of the entire system just by improving access of a litigant to information using an AI-based process by which every amendment is updated, and it's a one-stop shop for everything a person needs to know when they face a challenge from the outside in. Therefore, when you have information, there is no unnecessary litigation. You come in with information. Information gives you access. And it reduces the burgeoning burden upon our judiciary simply by approaching it from a data with AI from a citizen-centric perspective. I think this would redefine the parameters of what justice is and reduce the unnecessary burden by making a person a participant of the system, rather than an external party that looks at it from the outside in. This would be my, thank you very much.
Thank you, Sharda. Couple of, yes, this is a very good point of view. But, law is a profession, same as medicine. You can get so much from AI on symptoms of diseases, what are the possible medication and all. But then in the end, because of the hazard it can invite, you have to go to a doctor or a medical expert. You can't self-medicate. Similarly, on legal advice, you can have all the information, but still you require an expert. But then there is another dimension of it, and that is where the profession has to come out clean. That is the phenomena of what is called self-serving bias of an expert. An expert, if he has 3 or 4 options of advice to be given, tends to give advice more, which may little less benefit the client, but benefit him more, that he will have a sustainable client who will feed him with money and fees for a long time, rather than giving a very easy peasy quick solution which robs him of prospective professional earning. The second thing, and Bar Association makes a conscious effort not to have judges in every session, because criticizing a judge is a hazard, and criticizing it to their face is a bigger hazard for practicing lawyers. So what I'm trying to say is that in our system, this whole relic of old times of lordship, we have not shed this, not just that it is an institutional thing, it is written somewhere, but as lawyers we think we will please the judge from whom we have to obtain a judgment to continue to call them lordships and ladyships, which massages their ego. So ego massage has become an institutional facet, and that is why even while interfacing from the bar in terms of what Harish ji is saying, I think he could have his ideas could be amplified and heard in the corridors of judicial policy making echelons much more if he was an expert ego massager. Since if you lack in that attribute, your access to institution is very limited. And that is where somehow becomes a constraint for the Bar Association of India also, because we believe in a dignified discourse or a dialogue as equal partners in the administration of justice from the bench and the bar. So now I will invite Amarjit to do the batting in the last overs, and he'll do it from the crease he is occupying.
Thank you, Prashantji. So I'm sure you guys don't want to hear my 60-page PowerPoint presentation. When you are the last speaker, there are two distinct disadvantages. One, whatever you have to say is already spoken by the guest before you. And two, people are looking at the time when we have to leave. The third disadvantage I have, there is a tea waiting for you guys. So I am between you and the tea. But still, I want to make 3 points, and I've just noted in my one-pager, as you can see. So the first thing is, when I was preparing my presentation, I was just trying to see from, because I've done backlog reduction work. So my intellectually, I go back to that today at the current pace, if the judges, number of judges we have, which is in the morning, I think somebody said 22 judges per million, whereas the world standard is 100. And if the current pace goes, how long it will take to just dispose of the existing cases is 300 plus years. 300 plus years. So 300 plus years just to dispose of existing cases. Now, assuming the government is benevolent, the judiciary is proactive, and we have 100% appointment, there is no vacancy. Even then, with the current pace, even then there is no possibility of reduction. So something out of the box has to be done. And AI is the panache for that. And I'll tell you a live example. About a year back, when ChatGPT became a household name, I also experimented with it, tried to see if it works for me as a lawyer. And actually, I was quite disappointed. It was nowhere close to what I wanted from it and all the things that I had heard. So I dropped it and I continued to focus, having a junior, having a steno, doing the transcription, doing the typing, everything. Now, few days back, I had a deposition, as in I had to file an evidence for somebody. And it was about 30 pages of affidavit, which I went through meticulously, checked every paragraph. And when I was satisfied, I had to file it. I got it attested, signed by the client, the witness. And before filing, something came into my mind, why not just upload it and see if the artificial intelligence, I used Claude for that if it can give me something more. And I uploaded the petition that I had filed and the evidence that I had drafted and uploaded, and I said, please tell me if I'm missing out something. I just wrote these simple words. And out came the result in less than 2 minutes, pointing out at least 17 errors in that affidavit which I had drafted, which to my mind I thought was perfect, including a major flaw where I had taken a different stand in the petition and a different stand was given in the affidavit which was shown by my client. So I don't know whether I should say bless you to the artificial intelligence or curse myself for being stupid not to have looked through it. But whatever it is, I'm just telling you that today AI is a tool which, as young lawyers, you out all there, and we like middle age and there are seniors then, can use it to improve our existing skill sets, both as counsels in the court, as drafting lawyers, as somebody who needs research. So if I have to appear in a matter, or if I have to engage a senior advocate and I need some documents or need a written submission, 7 p.m., 8 p.m. in the night, I'm out having lunch, the senior advocate calls me and says, you haven't shared me a 2-pager note. I need that, please send it now. Now, traditionally, I would leave my wife at the restaurant and go home and draft it. But instead, lo and behold, I have Claude subscription. I upload the file, get the written submission, send it to my junior and say, please remove the Claude references there, forward it to the senior. So that's what is working. But this is what is existing. Now, have you heard of Moore's law? So there was a gentleman called Gordon Moore. In 1965, he predicted that the chip technology, which is there in our computers and everything, doubles every 2 years. So the technology improves every 2 years. And that rule or that law has been followed to the T till today. So the technology now we have billions of transistors in a chip. Now imagine that's just the chip. AI is something more. It is like Prashantji was saying, LLM, large language module. Now there is a test for it, just like Moore's law. It's called model evaluation and threat test for AI. Guess what is the law for that currently? It's 7 months. So the AI is improving, doubling every 7 months, and the time is not increasing, it is reducing. So if today it is taking 7 months to double the technology, after 2 years, it will take perhaps 6 months to double the technology. Now what am I, or where am I going with it? Our guests here have, in the earlier rounds also, now also we have got data that some countries have started accepting AI for some part of the work. For example, in Kerala High Court, now live transcription is used by AI technology called Adalat.ai. So you can go on the website and check out Adalat.ai. It is compulsory now, I believe, to use live transcription in Kerala for the courts, which we don't have here. So the same case which I was talking about when I filed the evidence, the cross-examination took place for 3 days from morning 10 a.m. till 4 p.m. in the evening with a lunch break of 1 hour, and we covered only 90 questions because every question had to be first typed, then explained to the witness. Witness would then have a follow-up question, then there would be an objection, so on and so forth. So 90 questions in 3 days, that too because the local commissioner was appointed. Imagine if we had to do it in court after one date, the next date would be after 3 months or 6 months. So this evidence would probably finish in 5-10 years' time. Now imagine if that technology which is applicable now in Kerala High Court is also compulsory here in Delhi and maybe other places. So much time can be saved. But that's not where I am going to. Where I am going to is the future. I know Dr. Harish has said that in our lifetime there is no possibility of AI taking over. But I have my doubts that at least just like COVID compelled us to adopt technology, and accept it even when we didn't have the resources. We had all the same arguments. You don't have internet, there are rural areas where there is no technology, you don't have laptops, only rich lawyers can afford laptops, we don't have scanning facility, etc., etc. And lo and behold, now predominantly everywhere we are using this technology. Yes, it is not 100%, but we are 80%, 70% there. So same with AI, we may resist it. We may say judges will not use it, judges will not be replaced, lawyers will not be replaced. Yes, it will be a tool for assistance, but I see a future, not now in the next 3 years, 5 years, but 10 years down the line, there is a possibility that cases up to a particular pecuniary limit, let's say 20 lakhs or 50 lakhs or 1 crore, will not be decided by judges, it will be decided by robo-judges. The lawyers will not waste time, and there is like, you have to file a written statement. How many days we require to file a written statement? 90 days? CP say 90 days with extended period of 120 days. Now, why do you need 90 days to draft a written statement? If I have the documents in front of me, I need time because I need to read each document, prepare my defense, ask the client what he has to say, and whatever holes are there, I fill it up with my legal acumen. But if all that data can be fed in, a written statement can be prepared in 5 minutes, 10 minutes, 15 minutes. And then you have time as a lawyer to use your skills, maybe 15 minutes or 1 hour or 2 hours to review those documents which are relied upon and which are not relied upon and approve a written statement. Do you need 120 days? Even despite you may be a very successful lawyer with 20 cases a day, still AI will be a great help. Now, what will happen in cases like summary suit, Order 37, or rent control matters where leave to defend is required, where it is predominantly all document-based? Why do you need time for, or why do you need, I was listening to a speech of Justice Manmohan where he said, robo-judges will never replace the judges because there is a human element to it. Human means that when the judge is when the judges are hearing your case, they have emotions, they have sympathy, they have their bias. They may have come from a rural background, and if they see a victim who has been tortured, so even though the law is against him, they may have a sympathetic view for that particular client. And they may mold the relief based on that, which AI will not do. I agree. But I ask myself in those cases where there is a case of contractual dispute. Why do you need a humane angle? If the law is there, if your client has taken money or if your client is entitled to money, why should there be a humane angle if it is not part of the law? So maybe up to a particular limit, or maybe the rule could be in the future that cases at the original side will be decided by robo-judges. So imagine I have a dispute today, this is my wild thought on this. What is my problem today with the judiciary or for my clients? Somebody has borrowed 20 lakh rupees and then he has not given. The client comes to you, he wants to file a suit. What is my advice? First advice, भैया 20 lakh के लिए तो तुम्हें लग जाएंगे 5 साल. And even when you get a decree, you have that famous quote that the problem for a litigant starts when he obtains a decree. So that's the next set of problem. What will happen to him? He will get a decree, but he will not be able to execute it. Now, see a reverse scenario. Everything is linked. I file a suit. 30 days or 15 days, there is a decree. Based on documents, based on reply, Chief Justice today told us there is a new app coming up where all the lawyers will be connected and the service will be done through the app. That means once you receive a service on the app, you will not be able to take a defense. Sorry, I didn't get the file, etc., etc. Now, in that situation, what will happen? You have a decree. His AI has got large data set. All his bank accounts, all his BINAM. You know, by the way, you know that income tax is now using that LLM model to track each one of us what we are spending. Even if we are not disclosing it, they have a pattern. They know that, okay, you are traveling, you are eating frequently in DLF mall, but you are disclosing and you are paying tax only 10 lakh rupees a year, but every meal outside is, let's say, worth 5,000 rupees. So something is not matching. Now a person whose data is available and there is a decree against him of 2 crore, 5 crore, 1 crore, 50 lakhs, he may not be able to avoid it in the future. Again, future is not tomorrow, but all the young lawyers, everybody including us, we should be scared. We should hone our skills, we should upgrade ourselves, and there should be continuous legal education, especially for AI. Tools, seminar, training program, only on AI to upgrade our skills. Now, my friend just gave an example that, as a lawyer, I may not be the best lawyer on civil side. A client comes to me and tells me, you file a suit for me. I may not be aware about a new amendment which has come that I have to, for example, in specific performance suit, there is amendment now. So you have to choose. You have to choose either specific performance or you have to choose return of money. I may not be aware about it, but when AI is drafting, and I am assuming in the future, not today, there are still a lot of deficiencies with it, but 10 years down the line, it may have the complete database available with all the cases in the country, all the arguments, all the judgments. There will be consistency. So lawyers will not make mistake when they are drafting because they have run through an app. And the outcome or the result would be, ultimately the judgment will be based on pure and pure facts and not on the deficiencies or technical objections that were missed by a lawyer who was not up to the mark. So that puts back the question to us, then what is our role? If everything is going to be done by AI, what is our role then? Where do we stand? Because then the lawyer, today also clients have started showing us, I have drafted this contract, please see if this is okay or you want to make any changes. So at least I am not getting paid for drafting an original contract, I am only getting paid for vetting a document. And that too, he is negotiating, aap nahi karoge to I'll get it done. So we are, all those are concerning me. And so in view of the fact that I had so little time, I wanted to focus on an alternative point that we should all be concerned, we should upgrade our skills, and we should not think that it is not going to happen. It may happen, it could happen, and the way technology is improving, it is a possibility that the government will be compelled to apply it to reduce backlog. Because see, what will happen ultimately? If I don't get justice, how does justice happen then? You take the law in your own hand. There's a Naki. Why is law and order problem? Because somebody has killed somebody, there's a rape, there's a murder, there is theft. You can see the guilty is there, he's out on bail, and it will take another 10 years for the case to be decided. So in your frustration, you take law in your own hands. But imagine all these small causes, cases, small items, they are out of that. One statistics I just wanted to give you, I am doing a matter in Supreme Court where we had obtained information under RTI that in DRT, 15 lakh crore cases are pending. the net worth of the cases which are pending, which are called OA, original application. And you know out of that, what percentage is 11 lakh crore? 85% of the cases is 11 lakh crore. And 85% cases is how much? Only 1500 cases. Rest 4 lakh crore is the remaining tens and lakhs of cases which are pending in the DRAT. Only 1500 cases constitute 11 lakh crore. So if focus is only on those 1500 cases, there is a special bench or a court, and there is AI and there's technology assistance. If you reduce that, you unlock 11 lakh crore cases from the system. That means that money comes either in the system, in the banks, the recovery, or the parties who are litigating get their money and they can use it to deploy it for the business. So on that, I'll just like to end. Thank you.
So taking cue from what the last statement of Amarjit was, that the courts have to be cognizant of two things. One, economic value preservation. Second, preventing economic value destruction. Unless until we are looking at it and are not looking at private party disputes as bilateral matters, not impacting anybody else, we are not discharging the due responsibility. Yes, you have to have causes which belong to common man. You have to have causes which are there in the criminal justice system. But then, unless until, what is rule of law? Rule of law means equality. Equality means, equitable distribution of resources. But if resources are destroyed and there are no resources available, what rule of law, human rights and everything we are talking about? With 1.5 billion people, with the kind of economy and size of economy we have, with the dismal per capita income we have, what kind of social justice we talk about? What kind of equality we talk about? We can't distribute poverty. We have to distribute prosperity. That is where we have to journey to. So the systems which are geared to distribute poverty are not fit for this country. And just to give you an example, legal systems may adopt later on, but there is a global technology policy platform just got launched on April 3. And I have been from behind mentoring that of sort with Sciences Po University in Paris and top professionals from top AI companies. So what is happening there, and some of the things which were shared by the top AI industry, means AI people who are working in the industry, like Louis Vuitton. Now, Louis Vuitton has a guarantee for the product. And if the product has any issue, they will repair it. Now, you have to map all the legal systems, everything. What is, a product has gone, what are the processes of passing through the customs again, going back, where it will be repaired, what are the economic costs, how to resolve it. Now they are using AI. Which product they have to replace, which will be cheaper or more efficient, just give a new one, and which product which we have to bring it back into the workshop and repair. So same way about justice, which is connected with small issues, connected to the documents, it will migrate to these systems. Like auto loans, You have taken a vehicle, you have taken a house, you have taken a washing machine, you have to pay EMIs, you have defaulted in that. There are documents to it. There is a complete track how much money has come, how much money has gone. So if you apply the law that no, you cannot appoint your own arbitrator, Perkins applies, and you say you can't do arbitration, you can't do this, how can you process so many claims? See, claims value does not justify resolution at the kind of procedural intervention you are trying to justify in an economic intervention which is such a small ticket size. So all this is going to migrate to the AI-driven automated systems of dispute resolution. It will decongest the other dockets. You know, for a 3 lakh auto loan, you have execution petitions. For check bounce cases, 1 car loan, 5-year, installments, each installment 16,000 rupees or 12,000 rupees, and you have as many check bounce cases. So that is where technology, AI, and all these things have to play a role. And if we don't allow that to happen, we are doing the biggest self-harm. So we have to differentiate on the scale of dispute, on the nature of dispute, on the economic impact of the dispute, on the human right aspect and impact of the dispute. And that is where bench, bar, policymakers have to work together. And that's where we have to find the strategies how to use technology in a proper way to address various problems encountering the system. So I think we had a good interaction today. We are 5:30. There is a dinner which will start at 6:30 to 7. So, but we will have tea served outside so that you don't have to go home, come back. Delhi's traffic is notorious. So we'll just hang around, have some tea and snacks. And Amarjit said he was in between the tea and snack, but he was a good protein snack in between. Thank you.
Thank you, Prashantji, for this wonderful session. Now I would like to thank all of you, especially people on dais, people off the dais, and especially the young students and lawyers, because they are the future of digital justice. Thank you very much.
ये तेरे बिल्लियां निशु